I will be accompanied by my colleague Shaivi Bhamaria today. She'll deal with the procedural aspect. Shaivi, will you like to share the screen once?
Sure, ma'am. Is my screen visible?
Yes, just make it on presentation mode and go to the
Yes,
first.
yes.
Yes, I hope that the screen is visible to all.
Yes, ma'am.
Thank you. So let us start with the topic today. Very good afternoon to everybody. The topic today is about concept, process, and treatment of claim under IBC. However, given that this is the first session of this series, I would like to deliberate upon the process in a brief manner. And then, of course, we will focus on the topic, today's topic. Shaivi, can you please just move the slide to the presentation part? Yes. So we have briefly covered the process, the entire overview of the process, which is IBC all about. As we all know that insolvency and bankruptcy code particularly deals with the insolvent matter, the company which are insolvent. Of course, there is a voluntary liquidation aspect as well, which is for solvent entities. However, we are not focusing on that part today. When it comes to insolvency and bankruptcy law matter, the process starts with the CIRP process, which is to give a chance to company to revive and get into the position, get its position back. And then when there is no aspect for the company to revive, in that case, the company goes into the liquidation. The process which involves the liquidation and CIRP process has been provided in the code itself, and that follows by the regulation, liquidation regulation, and of course CIRP regulation is there. So when it comes to the process, of course, the process starts with filing of application. The application can be filed by financial creditor, operational creditor, or by an insolvent company itself, by filing an application before the adjudicating authority under section 7 or section 9 or section 10, as the case may be. After filing the application, 14 days time period has been provided to the adjudicating authority. Of course, this time period is not some within which the adjudicating authority has to accept or admit the application, because it has been seen that given the burden on the adjudicating authorities, it is not possible for the adjudicating authorities to adjudicate all the applications pertaining to CIRP process or commencement of CIRP process within a 14 days time period. Hence, the process starts with the admission of the application by the honorable adjudicating authority. The moment the application is admitted, that day is treated as a CIRP commencement date, and the timelines that is provided in the code starts triggering with that event itself. So the timeline is provided as 3 days time period has been given to the IRP or RP. Basically IRP, because the initial stage of CIRP, there is a role of IRP only, the interim resolution professional, who may be suggested by the applicant or may be appointed by the adjudicating authority. So the moment the application is admitted, on the very moment the IRP is also appointed by the adjudicating authority. And from the date of appointment of IRP, the duties of IRP starts, which is from publication of newspaper advertisement. What is the reason, or what is the idea behind this newspaper publication? Idea is to invite the maximum claim which is possible with respect to the corporate debtor, maybe from the financial creditor or operational creditor or workmen or employees or statutory dues. So the IRP is required to make the advertisement for inviting the claims. After making this application, there is a window of 11 days basically for submission of claim. Why I'm saying this 11 days window? Because 3 days is already exhausted in newspaper publication. So if, say, suppose the IRP is providing or making the newspaper advertisement on the 3rd day, then there will be only 11 days window to the respective creditors to submit the claim. However, in terms of the provisions, the total time period is 14 days from the date of acceptance of the application or admission of the CIRP application by the adjudicating authority for the submission of claim. What if the claim is not submitted within the given period of 14 days will be dealt by my colleague Shaivi broadly. So when it comes to submission of claim, the 14 days time period is provided. And after that, a small window of 7 days is given to the respective insolvency professionals to verify the claim. Here again, there are two triggering points, because one says about the right of the insolvency professional with respect to verification of the claim, and the other says the rights of the liquidator with respect to the adjudication of the claim. So when it comes to insolvency professionals, the insolvency professionals are basically divided into three parts: IRP, RP, liquidator. The role of each of the part are different, and the duties entrusted thereupon are also different and are provided in the respective regulations. So this 7 days window is for verification of claim. After verification of claim, the IRP is required to constitute the COC. Once the COC is constituted, then the first meeting of COC has to be called, wherein the COC has to take the decision whether to continue with the IRP or to appoint the RP. Once the RP or IRP, as the case may be, is appointed or continued by the COC, after that, the role starts with respect to appointment of valuer, inviting of EOI with respect to resolution plan, then submission of EOI. After the EOI is submitted, verification of the COI and the acceptance of the EOI by the respective COC members. And again, when it comes to resolution plan, when the resolution plan is accepted by the COC, then the process of then the IRP or RP is required to file an application with the adjudicating authority with respect to the approved resolution plan. And once this resolution plan is accepted by the adjudicating authority, then the process of implementation starts, which is to be monitored by the monitoring committee. The other side is that what if the resolution plan is rejected or not accepted by the COC? In that case, the company goes into liquidation. What if the COC approves the resolution plan, however, ultimately the adjudicating authority rejects it? In that case, also the liquidation process will commence. What if no resolution plan received by the IRP, RP? In that case, also the liquidation process comes. And the timeline and this entire procedure for inviting the claim, verification of claim, then adjudication of claim as well starts, once again starts with the liquidation process, wherein the liquidator is required to once again invite the claim. If the claim is already submitted during the CIRP process, then liquidator now has a right to accept that claim only. As on the liquidation commencement date, the creditors have rights to update their claim, and based on that, the liquidator has right to adjudicate the claim. Here, one thing which is required to be noted is that this right of adjudication of claim is not available with the IRP or RP. I'll deal with this aspect broadly in the later part of the session. Shaivi, can you please just move the slide once? So the topic today is about claim, because the entire process is about claim. The corporate debtor, when fails to make payment towards the debt of the creditors, goes into such a situation where the respective creditors may entitled to initiate the application, file the application with respect to CIRP or liquidation commencement of the corporate debtor. Here, the topic which is about claim is how many creditors are there, whether all the creditors are entitled to the claim, and based on the claim, how in comparison to the claim, how many assets and what amount of assets are available with the corporate debtor. And once the assets are determined based on those realization, what amount of payment or in what hierarchy payment can be done to the respective creditors is all about the liquidation process. So understanding the meaning of claim is very important here. When it comes to definition of claim, section 3 subsection 6 of the Insolvency and Bankruptcy Code provides for the definition of claim, which says that claim is a right to payment or right to remedy for breach of a contract. Here, the concern is whether what is the concern when there is a right to payment? Right to payment when the amount is fixed, when that amount is crystallized or amount is known. In that case, the claim will be divided into two parts: financial creditor or operational creditor. However, when it comes to right to remedy for breach of a contract, here the amount is not crystallized. So here the other creditors comes into the picture. So when it comes to claim, the claim can be a right to payment or a right to remedy in case of breach of contract. What is the difference between claim and debt? Shaivi, next slide, please. So debt is an obligation with respect to a claim, which is due from any person.
So, madam, could you just kindly explain once again the difference between the two, right to claim and?
Yes, I'll just focus on that. I'll just focus on that part here while deliberating on the claim and debts part. I'll just focus on that particular part itself. So as I was mentioning that the difference between the claim and debt. What is the difference between a claim and debt? So claim is a right of payment or right in case of breach of contract. However, when it comes to debt, debt becomes an obligation of payment. Here, there is a famous ruling of Axis Bank Limited versus Edu Smart Services Private Limited, wherein incl has held that any person who has a right to claim payment as defined under section 3 subsection 6 is supposed to file its claim, whether matured or unmatured. So there can be two situations. Either the claim is matured or the claim is unmatured. When the claim is matured, you are saying that the claim is crystallized. It's about whether the claim is financial or operational. That's a substantial part. However, the claim is crystallized itself. But when it comes to unmatured claim, that is the claim which may arise at a future intervals. In that case, there is a contingency or contingent claim, which are included in that part, the other part, which is the right of payment in case of breach of contract. So this says that as the creditor is supposed to file its claim, whether matured or unmatured. It does not mean that the person whose debt has not matured cannot file a claim. So a person whose debt is not matured still has a right to file the claim. Whether it is converted into a debt or not, that is a next part to determine by the respective IRP or RP. The maturity of a claim or default of debt is not the guiding factor to be noticed for collating or updating the claim. This has been held by the Honorable NCLAT. I'll deal with this part at a later part of session in a detailed manner as well. Shall we please keep on moving the slides? So type of claim, when it comes to how many types of claim are there are financial creditor, there are operational creditor, there are workmen, employees, other creditors as well. When it comes to CIRP process, during CIRP process, of course, there is no bifurcation between the secured and unsecured creditor. This bifurcation comes at the stage of liquidation. During CIRP, it is about operational debt and financial debt. Whether someone is saying something? Okay. So operational debt is defined under the law, which says that is a claim in respect of supply of goods or services, including employment or government dues. In case of Tata Chemicals versus Raj Process Equipments, it was held that non-payment of advance money is not covered under operational debt. What is advance money? What was the case here? The case was such that the supplier has supplied the services but not paid any advance money there. So it was held by the bench that if there is no advance money has been paid, so there is no loss to the operational creditor as yet. The services just render or just services is about to render will not accomplish that part to be treated as an operational creditor. Hence, that particular part, when there is no payment involved particularly, or there is no loss to the operational creditor, that cannot be treated as an operational debt. So operational debt should be related with the supply of goods and services, wherein pursuant to supply of goods or supply of services, there is a loss to the operational creditor. So loss has to be established. In case of financial creditor, there are financial contracts, and of course, a time value of money has to be given value to. The intent of the debt has to be under a transaction, and that has to be contemplated.
What
Yes.
about contingent liabilities, ma'am?
I'll deal with that, sir. There are separate slides wherein we will deal in detail about the contingent liability. So there's a request to all the members that will take the questions, and I'll at the end of the session. And of course, there are the topics with respect to the contingent claims and difference between the claims, the debt and claims, etc. We have dealt in detail in the PPT, and we will discuss. We have sufficient time to discuss all these things, and we'll discuss about all these things in detail. So the back to the topic, which is about the intent of the debt. So of course, one has to establish that the intent of that debt has to be under a transaction has to be contemplated, and based on that, the classification has to be done, whether the particular creditor has to be treated as a financial creditor or operational creditor. That has to be determined based on the intent behind the transaction. Next slide, please. Shall we move to next slide, please?
Just 1 minute, Barsha, I'm having trouble moving slides. Just give me 1 minute.
Now this provision with respect to security interest. This is also a very important part when it comes to determining the claim. Security interest, whether a particular creditor is secured or not, has to be determined based on the security interest. So of course, as I said, creditors can be financial creditor, operational creditor, secured creditor, unsecured creditor, and liquidity holder. So when it comes to secured creditor, when I say a particular creditor is a secured creditor, so then I have to see what security interest that particular creditor holds. What is security interest? It is defined in section 331 of the code, which says that a right, title, or interest or a claim to a property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation, and which includes mortgage, charge, hypothecation, assignment, encumbrance, etc., etc. So security interest has to be established pursuant to two things. First, there has to be asset, and second, that particular interest has to be registered. Now, when it comes to security interest, there are concerns whether performance guarantee are included in this security interest or not. So the answer to that is no, because performance guarantee is about performance of a contract. So here, no particular assets, the underlying assets are not there. Hence, this cannot be treated as a security interest. There are rulings on that. One very recent ruling in case of state tax officer versus rainbow papers, which I'm sure that we all are aware of, wherein the Honorable Supreme Court has held that government dues with respect to state tax has to be treated as a secured creditor. So why this concern of treating the government dues as secured creditor arises? Because pursuant to operation of law, if say suppose pursuant to operation of law, some assets gets attracted to a particular assets get attracted or get attached by the regulatory authorities, in that case also it has to be treated as creation of security interest, and in that case the particular government will come at par with the other secured creditor. This ruling, of course, is subject pursuant to this ruling. There are several insolvency professionals who I believe that are getting notices from the state tax officer to treat their claim as a secured creditor and do the substantial or the needful part. However, here again the concern is same, whether the assets are attached to it. Security interest has to relate to an asset. So what are the assets? What are the underlying assets on that particular CIRP process or liquidation process, wherein the state government is charging that their dues to be treated as a secured creditor. And the second question that should arise is whether that security interest or that asset is registered or not. So based on these things, of course, the dues of either state government or the other operational creditors, if they are claiming themselves to be a secured creditor, has to be established, has to be verified. There are Sale of Goods Acts or Transfer of Property Act. Their provisions are not contrary as such to IBC. In any case, IBC says that the provision of IBC will supersede to the provisions which are not contrary. Yes. So, however, again, as I said, that the principle of the provisions of Sale of Goods Acts or Transfer of Property Acts, these are not contrary to the provision of IBC. However, the benefit has to be taken to the IBC to the extent possible with respect to these applicability. The third party security, whether created or not, that has also been dealt with, that has also been established or verified by the respective IRP or RP or liquidator, as the case may be. We keep on moving the slides, please. Then when it comes to rights of a creditor during CIRP process, the CIRP process, as says, the starts with the date of admission of the application by the adjudicating authority, and on the very same day the moratorium gets imposed on the entire process. What is about the moratorium? That no separate no proceedings can be initiated by or against the corporate debtor during this window of 180 days, which has been reserved for the CIRP process. Section 14(1)(c) specifically prohibits any action to foreclose, recover, or enforce any security interest which is created by the corporate debtor in respect of its property, including the assets, including the action under SARFAESI Act. So when it comes to foreclosing, recover, or enforcement of security interest, once CIRP process starts, after that, this process cannot be initiated against the properties of the corporate debtor, not even the under the process of SARFAESI Act. Part payment of sale consideration was made by the purchaser and no sale certificate was executed. So let us take an example wherein what happened is, say suppose this under SARFAESI Act, the asset has been sold or asset has been realized. However, only part payment has been made and the remaining payment is still pending. In that case also, it has been held in case of Indian Overseas Bank versus RCM Infrastructure Limited, that sale cannot be, that it cannot continue to enforce the security interest when the part payment is still pending. When it comes to proving the claim, there are separate forms which are provided for the financial creditor, operational creditor, in order to substantiate their claim, in order to file their claim. So that based on the documents submitted by them, based on the books and records of the corporate debtor, the IRP or RP or liquidator, as the case may be, can verify the claim. What is a detailed procedure to be followed with respect to verification of claim? That will be dealt with in detail by my colleague Shaivi Bhamaria. Then coming to the treatment of secured creditor in resolution plan. So the priority and value to be considered by COC is provided in section 30, subsection 4 of the Insolvency and Bankruptcy Code. There is a provision, there is a Supreme Court ruling in JP Kingston matter, wherein it is said that entitlement of dissenting financial creditor could also be satisfied. One has to see that the entitlement of dissenting financial creditor is also being satisfied pursuant to the resolution plan which is submitted. So during the CIRP process, it is all about the resolution plan, which provides for the revival of the company. So when it comes to resolution plan for revival of the company, of course, the COC is being formed by the financial creditor. However, one has to see that the hierarchy which is provided in section 53 of the code is not getting completely ignored, and that the interest of the other creditors are also protected pursuant to the resolution plan which has been submitted by the prospective resolution applicant. Of course, when it comes to liquidation process clearly provides for the hierarchy which has to be maintained and has to be followed by the liquidator while distributing the realized proceeds. However, when it comes to resolution plan, in case of resolution plan, the prospective resolution applicants submit their plan as to in what manner the payment will be done to the respective class of creditor, and what timeline. So this timeline, this manner are included in the resolution plan. And if this timeline is acceptable to the COC and also to the adjudicating authority, in that case, the process of implementation of the resolution plan comes into the picture. Shall we next slide? So when it comes to liquidation process, what are the options available with the creditors? When it comes to liquidation process, there are two options which are available with the secured creditor. One is either to realize the security interest, or the other option is to relinquish the security interest. What is realization? The realization is I am not wanting to follow the queue. I'm not wanting to give my asset to a common pool, and I want to realize my asset out of this IBC process. So say suppose I am holding one asset on as a security interest, and I have submitted that I don't want my asset to go into the common pool, and what I'll do is I'll realize my asset. If my total debt is of 100 crores and pursuant to realization of the assets, I'm getting 80 crores only. In that case, I have a right to file for my claim for the remaining 20 crore dues and to stand in queue with the other unsecured creditor. Why unsecured creditor? Because to the extent of the security, there was a security, I have already realized that asset. I have already sold and realized that asset. So I'm no more the secured creditor once I am realized that part of the security interest. So I have to stand in queue with the other unsecured creditor. The other part, which is to relinquish, is that I am ready to give my asset to a common pool where everyone's asset is there. In that case, whatever assets will be realized, in whatever amount will be realized pursuant to realization of all the assets by the respective liquidator, that amount will be distributed to me in line with the distribution that is to be made by the to the other creditors. So say suppose if other secured creditors are also getting 10% of their admitted claim, in that case, I will also get 10% of my admitted claim. So this is the difference between realizing outside the liquidation process and realizing under the liquidation process. Both the two remedies, both the two options are available with the secured creditor, and the window of 30 days is provided to the respective creditor to determine whether it wants to realize or relinquish. Why this 30 days period? Because earlier at the beginning of the process, it was seen that the creditors used to take long time to realize or to take decision whether they want to realize or they want to relinquish. And they used to sit with the assets for a longer period of time, which used to distract the very purpose of the Insolvency and Bankruptcy Code, which is about maximization of
वो तो ट्रबल शूट कर देते हैं ना, तो ठीक है.
I think Santosh was okay. I'm humble request to all the participants to kindly mute and I'll take the questions at the end of the session. So back to the topic, which was about realization or relinquishment of the security interest during the liquidation process. The secured creditors to whom the liquidator, the secured creditors are required to inform to the respective liquidator whether they want to realize or they want to relinquish within a window of 30 days of timeline. As I said, why this 30 days of timeline was given to them? Just to ensure that the very purpose of Insolvency and Bankruptcy Code, which is to maximize the value of the assets and to resolve the matter within a time-bound manner, is accomplished. Hence, this window of 30 days is given. If, say, suppose a creditor intends to sit with the asset or is not neither relinquishing nor realizing, in that case, after completion of the 30 days, that asset will automatically goes into the common pool and the liquidator will have the right to realize that particular asset. The presumption on the asset on being part of the liquidation state, as I said, where the period of 30 days is complete, after that, it is presumed that the creditor has already relinquished the asset and the asset will form part of the common pool of the liquidation estate. A secured creditor who used to realize is also required to pay towards a liquidation cost, has to share of the workmen, has the excess of realization, whatever he have, that also he has to contribute to the liquidation estate. So it is not that after realizing the security interest outside the liquidation estate, the creditor goes away or can dump with the all these expenses part which are otherwise other creditors are facing for. So even if the creditor intends or decides to realize outside the liquidation estate, in that case as well, the creditor has to contribute towards the CIRP or liquidation cost in the same line as the other creditors are contributing. Inter se priority during the liquidation is also one of the very, very important part while determining or verification of the claim. What is inter se priority between the creditors? Now say suppose on one asset there are several charges created. Some creditor has first charge, some has second charge. So based on the documents which are submitted by the respective creditors at the time of submission of claim, one has to determine as to which creditor holds the first charge, which creditor holds the second or subservient charge on a particular asset. It has been held by the Supreme Court in several rulings and even held by the incl as well, that right to realize the security interest under section 52 of IBC is restricted to a creditor that has exclusive charge or sole first charge on an asset and not the subservient charge holders on the asset of the company. There are certain rulings that also hold that distribution would be irrespective of any charge the creditors are holding prior to relinquishment of the security interest. One can see the rulings in TDB matter in this particular aspect. So realization of security interest outside the liquidation process, I have already covered that if a creditor particularly thinks or particularly determines that it wants to realize the asset outside the liquidation estate and don't want to follow the normal procedure, in that case, within 30 days window, it has to communicate its decision to the liquidator and it has to contribute towards the liquidation and CIRP cost. Then the excess of realized proceeds whatsoever there will be, that has to be contributed towards the liquidation estate, and the assets that cannot be sold to any person, the assets cannot be sold to any person to whom otherwise the sale cannot be done in terms of section 29A of the code, because 29A is about eligibility. That eligibility has to be maintained even in case a creditor decides to realize the assets outside the liquidation process. Shall we next slide, please? So now it comes to submission of claim, which is clearly about the procedural part as to what are the manners of submission of claim, what a particular IRP, RP or liquidator, as the case may be, has to see when it comes to verification of claim, what are the documents that are required to be submitted and what are the documents that are required to be verified or look into the mind by the respective IRP or RP while verifying the claim. This part will be dealt by my colleague Shaivi. Shaivi, please carry on.
I hope I'm audible to everyone.
Yes, you are.
Thank you. So I will be now dealing with the procedural aspects of submission of claims. This part I have divided into two parts. One is the first will be submission of claims during CIRP, and the second will be the submission of claims during liquidation process. Now, like Barsha mentioned earlier, the CIRP process, the process for submission of claims starts once the NCLT admits the corporate debtor under CIRP. So this is when the entire process of collation of claims from the IRP starts. One of the first duties of the IRP upon his appointment is to make a public announcement for admission, for basically inviting claims from different categories of creditors. I would like to mention that all this entire procedure for claims in CIRP is regulated by the IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016 that we colloquially refer to as the CIRP regulations. Now, let's first understand why this process of collating the claims from the creditors is done. What is to be achieved out of it? So in my view, three things are achieved out of it. First, it helps in formulating a a list of creditors on the basis of which the IRP has an idea that what amount of debt is due by the corporate debtor to its creditors. Second, it helps in constituting the committee of creditors. As we know, financial creditors form a part of the committee of creditors. So once the list of creditors is ready, the IRP knows how, on what basis he has to form the COC. And third, it helps the resolution applicant in a resolution plan in deciding what distribution has to be made to which creditor. So the entire process starts with a public announcement. The format for the public announcement has been prescribed by the CIRP regulations, Form A. It has to be published, as we know, in newspapers, one English newspaper, one regional language newspapers. Usually, this is published at the location where the registered office of the corporate debtor is situated. But the IRP here has a discretion. If he thinks that one majority of the business of the corporate debtor is held at some other location, say the corporate debtor has a major factory site at some other location, he can also have the public announcement published in the newspapers of that area. You have to disclose the public announcement on the website of the corporate debtor if the corporate debtor has one, and also put it on the website of the IBBL. The next question is, what must the public announcement state? So the public announcement is something which helps the creditors in submission of their claim. So it has to state those details accordingly. First, it has to state that in what forms they have to file their claims, where these forms can be downloaded from or obtained from. Second, it has to offer them choices of 3 insolvency professionals who will act as authorized representatives. The creditor in each class chooses one insolvency professional to act as their authorized representative. And the third is the last date by which they have to submit their claims. Now here, law provides a very short period of 14 days. Like Barsha said, effectively it becomes 11 days, because if the IRP makes the public announcement on the 3rd day of his appointment, law only provides 14 days from the date of the commencement of CIRP, like the appointment of IRP. So effectively, it is 11 days. So what happens to some creditors who come late? So Regulation 12 of the CIRP regulation provides an additional amount of 90 days from the commencement of CIRP, within which these creditors who have not submitted their claim during the earlier window of 14 days can come and file the claims. I will deal with this in more detail in my next slides. Now, along with the public announcement, the IRP will first have to also make a list of all available creditors from the books of accounts of the corporate debtor, and also separately send them a communication. You can do it through post, electronic means, whatever is comfortable. And this communication must contain the public announcement. Basically, the aim is to collate claims from as many creditors as you can within this window of 14 days, within this window of 14 days. So once the public announcement is made, this is when the claims from different types of creditors will start flowing. Now, the law has provided for different types of forms for different categories of creditors, and similarly, the different types of documents that they will file for substantiating their claim. So since no claim is taken at face value, they will have to submit certain evidences from their end, which will basically substantiate why they are claiming a particular amount in their form, in their claim. So if it's an operational creditor, the claim comes in Form B of the CIRP regulations. Operational creditors, it is not mandatory to submit a record available with the information utility, whereas for secured creditors, it is mandatory. Other than that, they can also submit documents like contract of supply of goods, invoice demanding payments, a copy of their GSTR1 and GSTR3B. Now, an IRP has to keep in mind that all these documents that are submitted, they have to verify it with the books of accounts and the records of the corporate debtor. Financial creditors, they submit their claims in Form C. For them, like I mentioned earlier, the records available with an information utility is mandatory. Along with that, they also have to submit the financial contract. Like say if it's a loan taken from a bank, then you submit the loan agreement, and you also submit the schedule of loans to evidence that out of that loan that you have agreed, that the bank has agreed to give to a particular to the corporate debtor, how much has been actually drawn and utilized by the corporate debtor. So that will be useful for the IRP in substantiating the claim. If a claim is filed by a class of creditors, it comes in form CA of the CIRP regulations, and the several documents that they can give is an agreement of sale or a letter of allotment, any other document that evidences the existence of their debt. Where claims are filed by workmen can file claims in two forms. They can either file it individually in Form D, or a class of workmen can together file their claim in Form E. Once again, for substantiating their claim, workmen can submit their proof of employment if they have filed any notice to the employer asking for their claims. That can also be filed. Residuary creditors who do not fall in these above criteria of creditors, workmen's, operational creditors, financial creditors, etc., they file their forms in Form F along with their bank statements or any documentary evidence that they come. Now, it has to be noted that supplementary documents or clarifications can be submitted by all categories of creditors at any time before constitution of the CIRP. So it is not necessary that they can file additional documents to substantiate their claims right before the CIRP is constituted. Also, a creditor can also update its claim. Say a claim of a creditor has been satisfied partly or fully from any source, then he will be required to file its updated claim with the IRP as well. Now, what happens after the last date of filing the claims has passed? So after the time period of 14 days, the IRP then gets 7 days to collate all the claims that it has received and also to verify the claims. So this is a very, very, very short period that an IRP gets, a period of 7 days. So while verifying the claims, the IRP has to keep in mind several points. First, like Barsha has said earlier, if it's a financial creditor and the creditor has a security interest, then you will have to verify the security interest that the creditor has claimed it has against the books of accounts. Say if any charge forms have been filed, you will have to check those charge forms. You will also have to see whether the security interest is the creditor has a sole security interest, whether they have any other pari passu charge has been created, or whether the creditor has a first charge or a second charge, etc. Now, there may be times that there might be inter se agreements between the creditors. Now, if these contractual agreements are disrupting the order of priority that is stated in section 53, then as an IRP, you have to disregard such an agreement. In case of operational creditors, you have to verify with the books of accounts the nature of services that have been provided by such an operational creditor, and also the invoices that they have shown to be raised, and whether that amount of debt is actually appearing in the books of accounts of the corporate debtor. The IRP also has the right to call for additional documents if it feels that the documents submitted by a particular creditor are not substantial. It always has the right to ask for additional clarifications, call for additional documents to substantiate the claim. Now, if the claim is contingent, or it is such that the amount that is filed in the claim is not precise due to a contingency, then the creditor has to make an best estimate of the amount that is claimed based on the information available and the books of accounts of the corporate debtor. It might be possible that several creditors file their claims in a foreign currency. Say if it's an ECB which has been obtained from a creditor in the US, that creditor files a claim in US dollars. So you are supposed to then convert the claim into Indian currency. Now the question will be, what rate of foreign exchange do we take? So law provides that the rate of official foreign exchange as on the commencement date of the CIRP, or if it's a liquidation, as on commencement date of liquidation, that rate of foreign exchange has to be taken and the claim has to be converted in Indian rupees. Now, after this entire process of verification of claims is done, The next step that has to be taken by an IRP is to formulate a list of creditors. This list of creditors has to be made category-wise. When I say category-wise, it is financial creditors, operational creditors, workmen dues, other creditors, etc. And this must contain the name of the creditors. Now, the actual amount that has been claimed by them has to be stated, and the amount that was ultimately admitted by the IRP has to be mentioned. And if there is a security interest, the same has to be mentioned. Now you will ask me, what is the purpose of this list of creditors? Basis this list of creditors, like I have also mentioned earlier, basis this list of creditors, the committee of creditors is formed out of the financial creditors. The list of creditors has to be always kept updated by the IRP, and it has to be kept open for inspection. It has to be disclosed on the website of the corporate debtor, on the website of the IBBI. It has to be filed with the NCLT, and at the first meeting of the COC, it has to be presented before the COC. Like I mentioned earlier, what if there is a delayed claim? So any claim beyond the amount, beyond the period of 14 days, we know that regulation 12 of the CIRP regulation provides an additional period of 90 days for the purpose of, for the creditor to come to the RP and file its claim. But what if a creditor is late even beyond the period of 90 days? What do we do in that case? So in that case, the NCLT and incl have in several rulings condoned the delay beyond the period of 90 days and have accepted the claim. The claim has to be filed any time before the approval of the resolution. The claim can be filed any time before the approval of resolution plan by the COC. And the principal bench of the NCLT in the matter of Edelweiss Asset Reconstruction Company Limited versus Adil Landmarks has held that the provisions of regulation 12(2) are directory in nature. It is not that any claim filed beyond a period of 90 days cannot be condoned. It can be condoned. So now we move to liquidation. While the process of submission of claims under CIRP and liquidation are somewhat similar, there are a few changes, a few tweaks here and there in these processes. Like we have mentioned earlier, that in CIRP, RP cannot adjudicate upon the claim. But in liquidation, the liquidator very well has the power to adjudicate upon the claim. It has the power to partially admit or even reject a claim, which I will deal with shortly. Once again, this process starts with public announcement. Here you have a time period of 3 days from your appointment as liquidator to file a public announcement. The same process of publication in the newspapers has to be followed: one English language newspaper, one regional language newspaper at the registered office, principal office. Once again, if you feel material business of the corporate debtor is at another place, you can very well publish it at that place. Law permits you that. Again, you have to disclose it on the website of the corporate debtor and IBBI. Now here, the contents of the public announcement are a little different from what they were under CIRP. Here, you do not provide a choice of authorized representative. Instead, you call upon stakeholders to update their claims as on CIRP. Now, when I mean update, meaning that any person who has filed a claim under CIRP can very well update his amount of claim as on liquidation commencement date. And you also call for fresh submission of claims from creditors. And you must also state the last date for submission or updation of claims. Here, a very long period has been provided compared to the 14 days that were provided in the CIRP regulations. The liquidation process regulations provide almost the double time. They provide for 30 days within which the creditors have the time to update their claims, because this being like the full and final call for submission of claims, after which any claim that you want to file, it's not in the hands of the liquidator to approve it. You will have to file an appeal with the NCLT to take on record to condone the delay that you have made in filing the claim and to take your claim on record. So that's why a longer period of time. Once again, you have different classes of creditors that file their claims in different forms. Since the documents to be submitted are very similar to that under CIRB, I will not be repeating, but merely the forms change. In case of operational creditors, it's Form C of the liquidation regulations. In case of financial creditors, it is Form D. Again, for financial creditors, it has to be noted, record with the IU is mandatorily to be filed. Workmen and employees once again have the choice to file their claims individually in Form E and by authorized representatives in Form F. Now, in case of workmen, the law provides that where the claim of a workman is appearing in the books of accounts of the corporate debtor, but the workman has not filed its claim. Even in that case, the liquidator is required to take such claims on record and make such claims will appear in the list of stakeholders. So this is a special provision that has been made with respect to workmen and employees. Other stakeholders can file their claims in Form G. Usually the category of people coming under other stakeholders are shareholders who file their claims under the residuary clause. Now, what time period does the liquidator have for verification of claims? Here again, the liquidator has a longer period for verification of claims. He has 30 days from the last date of receipt of claims. And also the liquidator has an additional responsibility. He has to adjudicate on the claim. So a longer period of time has been provided. Furthermore, the liquidator also has to see that any claim that was filed during CIRP but not submitted during liquidation is taken into consideration. Say, for example, there is a creditor X who has filed his claim during CIRP but has somehow failed to file his claim during liquidation. The liquidator has to take into consideration that claim also and include that in the list of stakeholders. Now, while verifying the claims, the liquidator has to also see whether there are any mutual dealings with the creditor and the corporate debtor, set off the amount and arrive at the amount which is either payable to the corporate debtor or due to the corporate debtor. Now, what happens if there is a delay by a creditor beyond this period of 30 days? It is natural that there will be a delay. So, like in CIRP, there is no extension provided of 90 days. This is here, the liquidator does not have the power to condone delay. Any delay on the part of a creditor to file a claim will have to be adjudicated by the NCLT. And you have 14 days time to file an appeal. Also, suppose if a creditor is not very happy with the decision of the liquidator, say the liquidator has admitted its claim partly or rejected its claim. What if you want to appeal? You can appeal to the NCLT. Again, law provides a time period for appeal, 14 days from the date of receipt of such a decision as per regulation.
Shaivi ma'am, can I have some query? So this is like all written in the books. So could you just have some kind of suggestion how to deal with this kind of situation to be in a safer side by the liquidator and CIRP while accepting a claim?
Like I mentioned, you have to verify from the books of accounts also. The law also provides that any claim that has been filed during CIRP but not submitted, you also have to take that into consideration. But beyond that, if there is a delay from the part of the creditor, it is not in the hands of a liquidator, it is in the hands of the bench to condone the delay.
So suppose you mean to say, suppose during the CIRP period, as on CIRP date, my amount of claim was say about X rupees. Okay. During the liquidation process, it might have added some value or you can take the interest into consideration. Suppose there is no specific request, or suppose that any creditor has failed to file during the liquidation process. So does that liquidator has the power to, add the interest?
Sir, I like to intervene here. So
Okay.
the concern is about the admission of claim as to what extent the IRP or RP or liquidator should admit the claim of a particular creditor. Because during CIRP, of course, the claim is up to the CIRP commencement date. However, during the liquidation process, the creditor has a right to file the claim up to the liquidation commencement date. And there's a substantial gap between the two timelines, the time of submission, the initiation of CIRP process, and this initiation of liquidation process. So of course, the creditor always has this window open to update the claim. So if a particular creditor intends to update the claim, that creditor may update the claim as on the liquidation commencement date. However, if say suppose the creditor does not file any fresh claim or any subservient claim, any different claim at the time of liquidation process, in that case, the law says that the claim submitted during the CIRP process can be considered by the liquidator. So the liquidator has to see the claim submitted by the respective creditor during the CIRP process and has to admit the same claim. When it comes to
claim.
addition of the interest, yes, I'm coming to your point. When you say about the addition of interest, well, I'll say here that liquidator is already entrusted with so much of task that it is not possible for a liquidator particularly to count on interest as on the liquidation commencement date for respective creditors. Say suppose the creditors have already filed claim during CIRP process, however not filed during the liquidation process, and are asking the liquidator to add on the interest in terms of their requirement, in terms of the interest applicable or the rate of interest that the respective creditor charges. It is not possible. This is not a duty of the liquidator to calculate the claim of the respective creditor. The duty is to verify the claims, to admit the claim, to adjudicate the claim. I cannot file the claim on behalf of the respective creditor. It is the right of the respective creditor to update the claim. If a creditor wants to update the claim, of course they can update the claim. However, they cannot ask the liquidator to get the claim updated on their behalf.
Well taken.
I hope
Well
I'm
taken,
clear.
ma'am. Yeah, very much.
Thank you, sir. Yes, Shaivi, you can continue.
Thank you, Barsha.
Ma'am?
Okay.
Excuse me. Suppose any creditor has filed a claim, but books of account are not available. Like in sometimes.
Which is a very common case, sir, especially in case of defunct company. This issue has been faced by several insolvency professionals that books and records of the company are not available, or if at all available, are not updated. Say suppose the liquidation commenced at the time of 2017 or 2018, or say suppose 2023. However, the books and records of the companies are available as of 2019. So at that stage, what an insolvency professional should do? Of course, the insolvency professional at that stage cannot rely upon the books and records of the company. So IRP or RP has to rely upon the documents that are submitted by the respective creditor to substantiate the claim, can take the assistance of the respective ex-management of the companies to verify if at all that the claim persists, if at all there was any further updation on the claim. And if say suppose neither by the claim nor by the ex-management nor by the documents or books of the company it is possible to determine the claim, in that case the IRP or RP always has the right to approach the adjudicating authority under section 60 subsection 5 to determine the claim as to what should be treated and how the claim has to be determined in that particular case.
Because madam, so far as the claim is concerned, like, the amount of claim I have received, but it is very difficult to find it in the books of account because they give that list of creditors in a consolidated way, not in a individual party-wise kind of thing. So naturally, the best option could be to approach the chartered accountant of that company or auditor of that company for getting the bifurcation of list of creditors or list of debtors.
Because sir, there are always there will be two types of creditor, as I said, financial creditor or operational creditor. If there are financial creditor, they have to prove the financial debt. The transaction must have happened through bank transfer or something. So that documents, that amount has transferred from the creditor to the corporate debtors account, that has to be established. In case of operational creditor, one has to establish that the goods or services were provided by the creditor to the corporate debtor. So this is all about the proof of claim. So based on that particular proof of claim, the duties of IRP, RPO, liquidator comes into the picture to verify the documents. And if say suppose the documents are not enough to substantiate, of course, they always have a window to go to the ex management of the company. Because what happens is, say suppose due to some reason, some internal dispute or some other reason, say suppose the company is not updating the financials of the company on the books and records, but there may be ledgers maintained by the company. So of course, the ex-management, the HR manager of the company or the accountant of the company must have a record as to how this claim persists or how this claim has come into the picture. So one can always take reference or assistance of the ex-management of the company to establish the claim, to substantiate the claim. And if in the circumstances is such that in none of the stages it is possible or none of the cases it is possible to substantiate the claim or adjudicate the claim, in that case, of course, the windows to go to the adjudicating authority is always open under section 60 subsection 5. Yes, Shaivi, you can continue.
Thank you. Now this entire process of once again admitting claims and verifying them culminates into a preparation of list of stakeholders. So in CIRP, we call it the list of creditors. Here we call it the list of stakeholders. Once again, the list of stakeholders has to be made category wise. The amount of claim admitted, the extent to which the debt is secured, the details of the stakeholders, they are all the mandatory contents of the list of stakeholders. The list of stakeholders has to be filed with the NCLT. Here we have a timeline that has been provided by the liquidation regulations, 45 days from the last date of receipt of the claim. So effectively the liquidator has 15 days because 30 days go in verification. So after that, within 15 days, you have to submit that list of stakeholders with the NCLT. Now, what happens if you are required to make any modification to the list of stakeholders? One case that I can think of for making a modification to the list of creditors is, say, a debtor transfers its debt. A creditor transfers its debt or assigns its debt from one creditor to the other. In such a case, both the assigner and the assignee come to the liquidator. They file the terms of such assignment, and the identity of the assignee is given to the liquidator, and the liquidator then modifies the list of stakeholders. Now, suppose the liquidator wants to add any additional information to the list, like say the change in identity of a creditor, it has to file an application to the NCLT. Any modification to the list of stakeholders can only be made after the directions of the NCLT. In case where there is an appeal under section 52, once again, the modification has to be made on the directions of the NCLT. Say there is a delayed claim and the NCLT directs the liquidator to verify the claims. The NCLT also gives a direction to the liquidator to file a modified list of stakeholders, depending upon what the amount if the claim is admitted, to file a modified list of stakeholders with the NCLT within the time period that the NCLT may grant. The list of stakeholders, again, has to be made available for inspection by creditors who have submitted the claim, by the directors, guarantors, and members of the corporate debtor. It has to be uploaded on the website of the corporate debtor and IBBI, like it had to be done for the list of creditors under CIRP. Now we will deal with delayed filing of claims. Here, we have seen that the law provides a time period of 30 days from the date of liquidation commencement. And what if there is a delayed filing and the NCL, is it possible first for a creditor to submit a claim after the stipulated time? If yes, if such a creditor has submitted a claim after the due date of 30 days, and in the interim, any interim distribution has been made by the liquidator, will the creditor be entitled to that interim distribution? And what will be the impact of such an interim distribution on the other creditors? I will answer all these questions one by one. First, coming to the admissibility of a delayed claim, the law is absolutely silent on whether a delayed claim can be admitted by the liquidator. The liquidation process regulations, the IBC code are silent, which means the liquidator does not have a power to accept delayed claims. So if a delayed claim comes to a liquidator, the liquidator has to reject it. And subsequently, the creditor can then file an application for condonation of delay with the before the NCLT under section 42 of the code. If the NCLT after hearing the application on merits decides that the delay on the part of the creditor was on a genuine reason, and that the debt is not time barred, it is within the period of limitation, it is under the period of limitation has not passed, the NCLT can condone the delay and ask the liquidator to verify the claims. And if the claim of the creditor is admissible, include him in the list of stakeholders and file a revised list of stakeholders. Now comes the second question of distribution of claims to the delayed creditor. Now suppose my creditor has come after a claim for delayed creditor has been accepted after the liquidator has made the first interim distribution sale. What happens in that case? Now here we can draw a reference to section 177 of the code. Though this section is applicable to individual bankruptcies, this principle may as well be applied to corporate liquidations also. That a creditor who comes delayed, he will not be entitled to disrupt the earlier distribution that is made, but he will be allowed that amount of distribution that has been the amount of the first interim distribution before any further interim distributions are then made by the liquidator. This has been confirmed by the judicial trends, like in the matter of Ganeshilal Gupta versus Bharatpur Oil Mills through the official liquidator. It has been held that if the claim is proved, it is within limitation period, it can be accepted and the creditor will be entitled to be paid by the liquidator. In the matter of General Rolling Stock Company also, the same principle has been upheld, that justice can be done to the creditor without disturbing the interim distribution already made to the earlier creditors. Now, I would like to explain this with the help of an illustration. Say here we will take two scenarios. In the first scenario, say an estate in distribution has three creditors, A, B, C. Each creditor has made a claim of rupees 3,000 each. Here, the liquidator has a cash in hand of 10,000. Out of this 10,000, before a delayed creditor, Mr. D, comes in, the liquidator has made an interim distribution of 50% of the amount of 50% of the claims of the creditors. So the liquidator has distributed 1,500 to each of Mr. A, Mr. B, and Mr. C. Now, at this stage, a delayed creditor, Mr. D, comes into the scene. His claim is condoned by NCLT, accepted by the liquidator, and he claims 5,000 rupees. How will the distribution now be made? Now we have 5,500 rupees available for distribution. So what the liquidator will first do is make the interim distribution that Mr. D has missed out. He will first give Mr. D that amount, which is 50% of his claims, rupees 2,500. After this, the final distribution the final distribution can be made to all the creditors, that is Mr. A, B, C, D. So the 3,000 rupees that are now left with the liquidator will be divided in the proportion of their claims. So at the end of the day, each person receives 71% of their claims. Now let's take a second scenario where there is a shortfall in cash. The claims of the creditors, Mr. A, B, C, remain the same here, but the liquidator only has 1,000 rupees in hand. Out of this, he has made a first interim distribution of 10% of the claims. He has given 300 rupees to each creditor and has now only 100 rupees in hand to make a final distribution. At this stage, Mr. D, a late creditor, comes in. He claims 4,000 rupees. Here, what will the liquidator do? So first, Mr. D will be entitled to the interim, like we said, he will be entitled to the interim distribution at 10%. However, the liquidator does not have 400 rupees to give him. So whatever money is available with the liquidator, 100 rupees will be given to Mr. D, and basically then there will be nothing left to give to the rest of the creditors. However, while the rest of the creditors have received 10% of their claims, Mr. D will only receive 2.5% of his claims. And here, Mr. D cannot claim for the deficiency since he was late in participating in the distribution process. So, this is, if we go to, if we have to form a conclusion, yes, a delayed claim can be accepted. He can come in any time before the filing of a final distribution is made, provided the debt is not time barred and the interim distribution that has been made will not be disturbed. The money will be distributed proportionately. This part I have already discussed, duties of the insolvency professional while verifying the claims. I will not be taking it up again. Treatment of claims in the CIRP stage. Now, how will the resolution applicant who has filed a resolution plan treat the claims that have been filed by the creditors? So the resolution
Ma'am,
plan.
I have one small query.
Yes.
It is like, it is seen that many a times while in the claim, statement of claim or list of creditors, it is meant that it's against some of the claims under verification. Okay, I am accepting a claim marked as under verification. So will that particular, creditor will be a form of, COC?
So claim of a creditor until unless crystallized will not form a part of the COC. So when it comes to these kind of claim, this surely you are talking about the contingent claim. So claims can be of two parts, can be decided into divided into two parts. One is which is crystallized, the other one which is not yet crystallized. One is which is funded, and the other one which is not yet funded. So when it comes to contingent claim, the amount which is yet to be established as to whether at all that will form part of a claim or debt or not. So in that extent, the particular creditor cannot be included in this committee of creditors. For including a creditor in a committee of creditor, the claim has to be crystallized. So
and suppose there are certain, madam, suppose there are certain documents pending from that, particular creditor. Even in that case, also till the moment, that all the documents are cleared, they can they cannot be, entertained in COC.
So there are stages. Of course, I'll deal with these stages once Shaivi completes her part. That when it comes to contingent claim, so till the time, say suppose as on the date of constitution of COC, the claim is not crystallized yet. So you cannot treat that particular creditor as a part of the committee of creditors. However, at a later stage, say suppose you receive the sufficient documents or whatever contingency was there has now been gone. In that case, that creditor will be treated at par with the other creditor and has to be included in the committee of creditors. However, the provision clearly says that the decision taken by the committee of creditors earlier cannot be disturbed pursuant to this new inclusion of the creditors.
Okay, and then we have to file the reconstituted COC.
For reconstitution, of course.
Okay,
During CIRP process, of course, you have to file for the reconstitution of COC, as well as during liquidation process as well. Someone has asked question in a window as well, which I have clarified, but I'll just repeat here again that the question was that is NCLT application required where modification is made within 45 days before filing the list with the NCLT. So when you have not even filed the list with the NCLT, NCLT is not aware that what is there in your list. So when NCLT is not aware what is there in your list, there's no question of filing any modification. The question of filing for application for any modification comes only once the list is there with the NCLT. Once you have prepared the list and the list is there with the NCLT and you are trying to make any changes, any modification in that particular list, then only the question of filing this application with the NCLT with respect to modification of claim arises. And this is very beautifully dealt in the regulation 31 sub-regulation 3 of liquidation process regulations. I hope I'm clear, sir.
Yes.
Thank you, sir. Yes, Shaivi, you can continue.
Thank you, Barsha. So relevance of priority in resolution plans. When a resolution applicant makes submits a resolution plan, he must take into consideration the priority laid down under the mechanism that is laid down for distribution under section 53, what we colloquially call as the waterfall mechanism. What is a waterfall mechanism? I will just take it in a few minutes time. So as per section 32B of the code, special provisions have been made for operational creditors and for the financial creditors who are dissenting or who do not approve the resolution plan. Now, why are special provisions are made for these two? Because operational creditors, if the committee of credit, if a corporate debtor has financial creditors, it is hardly that operational creditors have any role to play in the CIRP process. And dissenting financial creditors, because if the majority of the majority of the COC votes in favor of the resolution plan, then the voice of the dissenting financial creditors is crammed down. So in order to give equal importance to them, these special provisions have been made under the code that an operational creditor in a resolution plan, the operational creditor must receive at least the liquidation value, or if the amount that is distributed by the resolution applicant under section 53, whichever is higher, and the dissenting financial creditors must be paid the liquidation value. Now, it is the duty of the COC to ensure that the resolution plan that is approved by the COC is feasible and viable, and it takes into account all aspects, including the manner of distribution of funds. This has been upheld by the Honorable Supreme Court in the matter of SR Steel versus Satish Kumar Gupta. It is possible that other creditors may face a haircut. However, the priority that is there under section 53 has to be maintained. Again, in the matter of Vistara ITCL versus Dinkar Venkata Subramanian, the Supreme Court has acknowledged that these amendments in section 30 of the code, which have been brought in 2019, by way of which this distribution to the operational creditors and the dissenting financial creditors was added to the code, is basically to ensure that they receive an amount that is equal to what they would be entitled to under liquidation. Now, treatment of claims under liquidation or priority of distribution under liquidation. This is where section 53(1) of the IBC comes into force, comes into picture, what we call the waterfall mechanism. Now, what exactly is the waterfall mechanism? Let me give you an example. Suppose you are hosting a dinner party at your house. I'm hosting a dinner party at my house and I have invited 20 guests. Now, suddenly, unforeseeably, instead of 20, 30 people have come in. What will I do? Assuming that I do not have the option of making more food and I do not have the option of ordering food from outside, what will I do? So a decision will have to be taken as to who will eat first so that the food on the table is enough for all. Say, there are different ways of dealing with it. We may decide that the hosts who are there, basically those who are hosting the party, will eat later, or if possible, or if the food still falls short, eat nothing, and the guests are allowed to eat first, or maybe the elderly people are allowed to eat first, and then the youth can eat. So this is exactly what is the waterfall mechanism when it comes to distribution under liquidation. It decides the priority in which the money that is available in the liquidation estate has to be distributed so that there is enough for all. So the topmost priority has been given to CIRP costs and liquidation costs. These costs have to be paid in full. What constitutes of CIRP costs has been very well defined under section 5 of subsection 13 of the code and regulation 13 of the CIRP regulations. Broadly, these amounts include amounts payable to those suppliers who have supplied essential goods to the corporate debtor, or any fees that has been payable to the authorized representatives that have been nominated by the creditors. This may also include persons whose rights have been prejudicially affected during the moratorium, the fees that is payable to IBBI. Liquidation costs include first and foremost the fees of the liquidator, the remuneration that has been to be paid by the liquidator for professional services if the liquidator has hired an auditor. So the fees to be paid to such auditors, the costs that the liquidation incurs for verification of claims. During the period of liquidation, we know that the liquidator is supposed to maintain the corporate debtor as a going concern. Any cost that has been incurred by the liquidator for that, any cost of interim finance, anything that is payable to contributories, etc. All these costs, CIRP, liquidation costs, are top one priority. Next comes your workmen's dues. I must emphasize this is workmen, not employees, only workmen. Workmen's dues for a period of 24 months prior to liquidation commencement date, and secured creditors who have relinquished security interest. Workmen, the meaning has to be taken from Section 326 of the Companies Act. Next comes employees' dues other than workmen for a period of 12 months prior to liquidation commencement date, after which comes financial debt owed to unsecured creditors. Any financial debt that unsecured creditors may have towards the corporate debtor, the next priority is given to that. Statutory dues, that is the dues of the central government, the state government, and any contribution that has to be made to the Consolidated Fund of India. Those dues come next in priority. Along with the statutory dues come remaining amount towards secured creditors. Then come the residuary debts and dues. These are those mentioned, these typically include operational creditors who owe unsecured debts. Next come preference shares. As we know, preference shareholders have a priority to payment of their premium and for the payment of their amount of the share capital. So the preference shareholders will come one notch above the equity shareholders. And the last come the equity shareholders, who are basically the hosts who get more often than not, who remain hungry or just get the leftovers of the food. Here I am done. I would now like to invite Barsha to take up some parts of going concern sale.
Yes, so I'll start with this, some of the factors with respect to the going concern sale. Of course, I know that this is not a topic today, but this is relevant to discuss when it comes to determining the claim and verification of claim, etc., as to what happens of claim when it comes to going concern sale process. So the factor that are relevant for determining whether corporate debtor should be realized by way of a going concern sale or not are, of course, the responses from the resolution phase, expected responses from the potential buyers, whether they are ready, whether they agreed to buy the corporate debtor in a going concern mode or not. Then the status of the assets, the core assets of the corporate debtor, the human resources, how many employees, workmen, etc. are already there. Then the relinquishment of security interest, whether the same has been done or not. Then the general market conditions and the cost involved and available in the liquidity process. The better utilization of resources can be done by way of a going concern sale. Why I say so? Because when it comes to going concern sale, you are not only selling the assets, you are also selling the license, the agreement, the contract attached to that particular assets. So of course, the prospective buyer who are standing in queue or was standing to buy the corporate debtor, the assets, the particular business of the corporate debtor as a going concern will be benefited more when the particular assets is getting sold by way of a going concern sale. However, of course, the concern is that if at all the assets is in a position to continue as a going concern, or is it already a gone concern, something which cannot be continued in a future prospect, or something which do not have any future prospect. So if at all there is any future prospect of a particular assets or a particular business of a corporate debtor or the corporate debtor as a whole, it is beneficial always to sell, to try to sell the asset of the company or the company or the particular business of the company as a going concern sale. Shall we move to next slide, please? Keep on moving. So the going concern sale after the lapse of timeline, what does it mean? That there's a timeline of 90 days provided in the regulation, which says that the IRP, RP, the liquidator has to try to sell the assets by way of a going concern sale within a window of 90 days only. So this 90 days maybe for in future maybe stringent to further 30 days only. As you all are aware that the more the regulation is getting evolved, or the more there are changes in the regulation, the timeline for the IRP or RP is getting stringent or is getting shorter, just to achieve the overall perspective of the IBC code, which is to close the process within a time-bound manner. So, if at all it is possible to sell the corporate debtor within a given period of 90 days, and if say suppose it is not possible to sell the corporate debtor within a given period of 90 days, is it still open for the liquidator to sell the assets as a going concern in future as well? So this is a question which was determined by the adjudicating authority in case of Gujarat NRE code, wherein it was held that the liquidator shall try to dispose of the corporate debtor company as a going concern after publication of a notice in newspaper with the reserve price, which shall be equal to a total debt amounting including interest, and maximum period applicable for trying to sell the corporate debtor as a going concern will be only 3 months from the date of order. There are several rulings again after this Gujarat NRE coke matter as well, wherein it was held that liquidator shall always try to maximize the value of the assets. If say suppose the value maximization is possible pursuant to going concern sale, that window is always open for the liquidator to achieve through. Shall we presentation mode, please, and move on to the next slide.
Madam, what is the procedure?
Sorry, sir.
Business on is going concern. What is the procedure?
I'll just deal in shortly about this process, sir. Of course, there are in the series there are topics assigned to the next speakers as well, who will deal in detail. But of course, I'll deal in a brief manner about the process to sell the corporate debt as a going concern. So, sir, when the liquidation process provides for the manner of realization of assets of a corporate debtor, says that you can sell by way of a piecemeal, selling the assets, each individual assets separately, or you can consolidate the assets and sell the same by way of a slump sale without assigning individual asset value to the assets. Or you can sell the business of a corporate debtor as a going concern, not the corporate debtor itself, but a particular business. Say suppose a corporate debtor is involved in 2-3 business undertaking. There are 2-3 business undertaking, and you are intending to sell a particular undertaking. Say suppose a corporate debtor has a particular factory in somewhere, and the other cable manufacturing factory or some other factory somewhere else. So they want to sell a particular undertaking to the prospective buyer as a going concern. They can, of course, sell the corporate debt as a going concern, for which the process is same, is to invite the invitation or the expression of interest from the prospective buyer. And once the the liquidator receives that claim, or the liquidator receives the possibility or the interest from the respective buyers, in that case, the liquidator can always move ahead with selling the assets. When it comes to liquidation process, the liquidator do not have to go to the adjudicating authority for the manner of sale. It is open for the liquidator to realize the assets in the manner the liquidator thinks is the best interest of the creditors and for the company, for the beneficial liquidation of the corporate debtor. So it is always open for the liquidator to decide upon this, and the liquidator can sell that particular business of the corporate debtor as a going concern. The other option is, of course, selling the entire corporate debtor as a going concern. Say suppose when there is only one factory, there's only one business in the corporate debtor, there's a prospective buyer who intends to buy the corporate debtor as a going concern. While deciding the corporate debtor as selling as a going concern, of course, the liquidator has to mention that what all rights, what all contracts, what all licenses will be carried on along with the assets or the business which are available in the corporate debtor. So that has to be clarified in the info memo, which will be provided by the liquidator to the prospective buyers. And of course, after getting the prospects from the prospective buyers, the liquidator can move ahead with conducting the e-auctions and the best bidder, the successful bidder, once the bid is submitted and finalized, the liquidator can move ahead with incorporating the sale certificate with respect to this going concern sale. So
Barsha ji, what if in case, like, I have got a corporate debtor in my hand, which was closed before the CIRP 2 years back. So in that case, how to determine that company would be as a going concern based on the parameters like you just suggested? None of those exist, come into existence.
So when you say that you are intending to sell the corporate debt as a going concern, that does not mean that the only factor to determine whether the company is going concern is the financials of the company only. So let us take an example of a car. Say suppose if you think that by repairing a car a bit and providing a fuel to a car, you can make the car to run. In that case, the car is in a movable condition or a going concern condition of a company. So when say suppose you see that there's a potential in the company that by giving certain fuel to the company can run, and there are contracts, there are licenses which will ultimately be beneficial for the prospective buyers, and there are interest of the buyers in that regard as well, you can always sell the corporate debt as a going concern. So the
Irrespective of
prospect has
fact,
to be
like,
seen, sir.
Okay, irrespective of fact, like, whether the company was running in the past 2 years before it could be admitted in CIRP.
Yes. Say suppose there are possibility that the company was in a running position. However, because of a lack of manpower or lack of the fund, the corporate debtor, the management of the corporate debtor couldn't run the business of the corporate debtor, and that is why the factory ultimately leads to shut. However, there is always an option for the prospective buyer to insert certain fuel, to insert the manpower, to insert the fund in the company to the extent is required, and to make the company run. So if at all there is a potential to make the company run in future, of course that potential can be utilized and the corporate debtor can be sold by way of a going concerns.
That means it has to be evaluated by the liquidator,
Yes,
the
of course.
potentialities of it. Okay.
Yes.
That means, ma'am, just please clarify me. We can sell the company, total company to the buyer.
Yes, sir, of course you can sell the entire company to the buyer.
That means
there are
name will
people-
be transferred
Madam,
to.
madam, not the liabilities, only the asset would go.
Sir, liabilities are never paid, sir.
Yes.
If you see the comparison that is there in the screen, sir, it is clearly mentioned that whenever it comes to liability, the liability is always is to be paid in terms of 53s. So because whenever, if say suppose you are selling the assets by way of a slump sale or by way of a going concern whatsoever, the prospective buyer is always interested in the fuel that you are providing or the assets that you are providing.
Exactly.
How many weightage is there? But if you burden the corporate debt of the prospective buyer with the liabilities, none of the buyer will be happy to purchase the assets, sir. So it is already been held by the respective regulatory authority, by the respective adjudicating authorities, that liabilities has to be paid in terms of 53 only out of the realization from the liquidation state, no matter what. So you cannot burden the prospective buyer from the liabilities of the past liabilities of the corporate debtor until unless specifically admitted to or unless specifically agreed to by the prospective buyers to take on certain liabilities.
Okay, madam, just I want to more clarify that so suppose the company name is XYZ Company Limited. So one buyer comes and he wants to take over the company. Can you sell the company as XYZ Company Limited and transfer the shares?
So shares will not get transferred. Shares will get extinguished, and the new management, there will be new management. The prospective buyers will have to infuse the share capital in the company, and then
That means that company name XYZ will be continue or not?
So that again is depends upon the prospective buyer. If buyer wants to continue with the name of the company, of course that can be continued. If the buyer intends to change the name of the company, that will form part of the resolution plan in case of CIRP or in case of liquidation process in the agreement itself, which will be entered into between the liquidator and the prospective buyers.
Okay, that means that can be continued. That name.
Yes, of course that can be continued.
Okay.
Ma'am, if the
But of
liability
course,
will be there.
I'll just like to add on one part here that Of course, one has to see that because of the continuing name, that the earlier name of the corporate debtor is continuing, that shouldn't be the aspect that the prospective buyers being burdened with the past liabilities of the corporate debtor. So there has to be a clean slate principle, that what you are providing to the prospective buyer is a clean slate. There should not be any liabilities in the slate that you are providing to the prospective buyer. Yes, ma'am, you're saying something.
Ma'am, actually, I want to ask that if there is any liability for GST department as well as income tax department, so what will be happening after this sells as a going concern with this income tax liability and with this GST liability?
Ma'am, liability to whatever extent, whether it is income tax department, whether it is government dues, or whatsoever liabilities are there, will have to be dealt with in terms of 53. So in 53, you must have seen that government dues
Yes.
are also there. The income tax or the GST, as maybe you are referring to, is under the priority of 53. So if, say, suppose some of the creditors are not paid, some of the creditors, say, suppose only financial creditors are paid to some extent, and all the other creditors who were standing in queue of 53 were not paid, in that case, they cannot go to the prospective buyer and ask for their claim to be paid.
Yeah, Barsha, just to take this, question further.
Yes.
Suppose that corporate debtor doesn't have fund to, meet all these liabilities under, section 53. Can the government department initiate action against the the director of the company for recovery of those liabilities under income tax and GST and all other statutes?
You are saying about the ex-management of the company, right?
Yes, yes.
Yes, yes. It is always open for the prospective, respective creditors to initiate proceeding against the ex-directors of the company, because some or the other way, it is because of the lack of the ex-management of the company that the company has gone into the CIRP or liquidation process. So it is always open for the respective regulatory authorities to move ahead proceedings against the ex-management of the company.
Ma'am,
So the liabilities of the company is getting washed off, but not the directors. Directors are not getting any relief pursuant to the CIRP or liquidation process.
Liquidation.
Yes.
If ma'am 138 section is there against the director of the company, so it will again continue.
Sorry, ma'am, will you please?
138 proceeding was there against the ex-director of the company, against the company. So if the sales is as a going concern, so it will continue.
Of course, ma'am. As I said, that the clean slate that you are providing to the prospective buyer is from the perspective of the company that you are selling, and not from the liabilities of the directors. The directors are still liable. The directors are still answerable. The directors are still questionable for the conduct that they have done, and because of which the company is facing the situation or has faced the situation. So they are not getting any clean slate. They are not getting, any kind of remedies pursuant to the CIRP or liquidation process. One cannot say that the liabilities of the directors are also getting extinguished pursuant to the completion of the CIRP or liquidation process.
Okay,
Ma'am,
fine.
I have a query
One more
here.
question is there.
Yes.
Ma'am, in case of sales as a going concern, if AA has ordered that you have to publish notice in the newspaper, and notice has been published and the amount has been given, but the e-auction has not been done. So ma'am, can sales as a going concern be done in this format?
Ma'am, e-auction is not being done means, for the time being, say suppose e-auction is not being done, but it is
Yes.
always open for the liquidator to give a next date of e-auction. There may be certain reason because of which the auction couldn't be completed on the given date which was mentioned in the EOI. But liquidator, it is always open for the liquidator to announce the next date of e-auction if the liquidator has received that much of interest from the prospective buyers.
So means
Ma'am, I have a query here, ma'am.
without e-auction, it cannot be done now.
No, auction has to be done, but says there are other options as well, which is of private sale. In case of private sale, of course, you have to take permission of the adjudicating authority
Fine.
to sell the assets by way of a private sale.
Ma'am, I have a query here.
Yes.
Will your answer be different if the government department, which has annexed the properties of the corporate debtor, even
Of course,
prior to the
sir.
commencement of CIRP?
So I cannot
they
go
still-
beyond the Supreme Court ruling, sir. The Rainbow Papers
yes,
ruling in Supreme
Rainbow
Court is very
Paper,
much
yes.
clear in this regard, sir.
Yes,
Ma'am,
I'm just asking
ma'am,
about that only.
Ma'am,
No,
review petition is
what is
also
the-
there.
No.
Yes, Mr. Shankar, come, go ahead, please. Sir.
Sorry.
It's
In the
all right.
wake of Rainbow Papers,
So I
will
just
the
conclude
government
this.
department
Yes, sir, please
will
continue.
be at par. Will be treated at par with the secured creditors, because Supreme Court has categorically held that government dues must be paramount and that should be paid, and they should be treated at par with the secured creditors. So I just want to have your opinion in this regard. Thank you.
Sir, I cannot go beyond something that has been established by Supreme Court, sir.
Oh.
So it has been established by Supreme Court now. Of course, that is questionable. The MCA has already given the suggestion on this, that
Yes.
if this will be the law, and this so the very purpose of IBC, or the very hierarchy which has been provided in section 53 will get
No.
tilted. So there are discussion paper on that, but yet the concretized steps to be taken
Because-
by IBC is yet to be seen.
Because in one of the cases, even prior to the commencement of CARP, the income tax or the GST has attached to the properties of the CD. So the company, even at the commencement of CARP, the company is not vested with those properties. They cannot deal with those properties. Even the resolution applicant who came in and took over the company cannot deal with those property. Na?
Sir, if say suppose before CIRP commencement, if the property
Yes.
has already been attached, so when the property has already been attached, in that case, the particular government is also having a secured creditor, is also being treated as a secured creditor.
Attached, but
Because
not
there
sold.
No, not being sold, because in
Yes.
case of secured creditor, a secured financial creditor as well, they hold the security interest. They do not sell their assets. They hold
Yes.
the security interest on a particular assets. Eventually, they are given a right either to realize or to relinquish, but that is subsequently post commencement of the process.
Yes,
So
they have the
similar treatment will
option.
be given to government dues as well.
Yes, they can always stand outside the scope of binding up under section 52 also. Now
Absolutely.
they have attacked the property, but not they are not affecting any sale over it. But the people are protesting over it. In the wake of rainbow papers, I want to have your view on this. Thank you.
That is what I said. This is something that the Supreme Court has already held, so I cannot go beyond Supreme Court's
Yeah,
decision.
perception differs now, ma'am. That's why. Thank you.
Thank you,
And
sir.
ma'am, this decision of Supreme Court is under review. Any idea? Can you throw
Yes,
some light?
sir. There is a discussion paper issued by IBBI wherein this concern has been discussed, that Supreme Court has held that government dues should be treated at par with a secured creditor. So, and pursuant to that, the IPs have started getting the notices from the state government state government department saying that treat their dues as a secure creditor. So now it is becoming very difficult for the IP to adjudicate as to if, because the dues of state government is huge, is such a huge amount that treating the same at par with the other creditor will be very difficult, and there will be hardly any chance for other creditors to have anything. So of course, there is a discussion paper going on, but it is yet to be crystallized until unless IBBI is coming up with a concrete crystal amendments to the rules and regulations. I reserve my right to comment on this, sir.
Then what should IP and liquidator do under certain
The
circumstances?
law still holds good. Now, ma'am.
So currently,
Rainbow
IP.
papers.
Yeah.
Yes, sir, Sangha,
Yes,
sir, you are
please
saying.
go ahead. No. What
So
I'm
what
asking,
IP
I
and
just want to
liquidator?
know the dictum held by the Honorable Supreme Court still holds good. It was not reversed asset.
Yes, sir, yes.
Right.
So still the time the IBBI is coming up with any changes in the law, of course, one has to abide by the Supreme Court ruling. However, of course, the concern arises that if someone is treating
Okay.
or asking themselves
Exactly.
to be treated as a secure creditor, then as per the rules and responsibilities of the IRP, the question or the concerns before the IRP or RP is always that on what particular assets you are claiming the secured interest. Then the second question is whether the security interest is registered or not. If registered, where are the documents? So these are the questions which always have open from the perspective of IRP or RP or liquidator to ask for while determining or adjudicating the claims.
Madam, I have a question on the slide of yours, wherein
Yes.
you have said that
Thank you.
liabilities have to be settled as per.
Sir, can you please just increase the volume as
Yeah, I have a question on this slide, wherein
Yes.
you have indicated that liabilities have to be settled as per section 53. My doubt is, can there be a resolution plan which talks of settlement of liabilities subsequently, or all settlement has to be immediate?
So it is always open for the resolution applicant. If say suppose I'm a resolution applicant and I am myself, I'm saying that I'll take on this particular liability. So it is always open from the resolution applicant. However, the fact is that none of the resolution applicant or the prospective acquirer intends to take on the liabilities of the corporate debtor. However, as I already said this before, that if say suppose any particular acquirer intends to specifically acquire the liabilities as well, it is good enough for the liquidator or the IRP or RP to give that window to the particular acquirer to acquire that liability as well. There's no restriction on that part, sir.
So what will happen is then 53 becomes the distribution as per 53 becomes the current creditors. So
Sir,
if the-
IBC is such a law which of course has to be seen in light with the code, but practical aspect you cannot ignore, because the idea is to maximize the realization, but you cannot ignore this part that till now in none of the resolution process any of the operational creditors or unsecured creditors have been paid, because the hierarchy is such that the amount realized out of the cases admitted so far is not enough to make payment to the first priority creditors itself. So it is there are hardly any cases wherein the subservient creditors who are standing in queue beyond the first priority creditors are getting anything out of the realized proceeds. So of course, say suppose if some prospective acquirer is coming forward and asking that they are ready to take this particular liability, it is always encourageable to allow the particular acquirer to take on that liability if they want.
Okay, thank you.
But you cannot force the particular acquirer to take on any liability, because liability has to be paid in terms of 53 only until unless specifically acquired or asked for by the acquirer as well.
Okay.
And ma'am, there is a very peculiar kind of claim nowadays in the offering is that, see, that so far as operational creditors are concerned, one can make out that you have supplied the material and you have all the supporting documents with you. But so far as some intelligence departments are there, wherein certain GST matters or the circular transaction, they have found it out. And based on that circular transaction, they have come out with certain claims, which has been internally approved by them, and which has now been lost with the IRP or the liquidator to consider that claim. So how to deal with this kind of situation?
Sir, till the time the claims are contingent, say suppose pursuant to a circular transaction, someone has determined that this amount can be treated as a claim, and let us file the claim. So one has to see if at all there is any proceeding initiated against that particular claim or not. If there is a claim, if there is a proceeding initiated against that claim, one cannot accept the claim, and that claim has to be said as under verification or under adjudication.
Okay.
Till the time the amount is getting funded.
Okay.
Or getting crystallized.
Getting crystallized.
Yes.
Ma'am, I want to ask one question. Ma'am,
Yes.
at the time of CIRP, claim has been admitted, but at the time of liquidation, claim has not been admitted earlier. But ma'am, after this, September 2022, one new IBBI amendment has came that we have to admit all this.
Hello. Hello. Ma'am, am I audible to you?
Yes, ma'am. Actually, my question is this. After September 2022, the new amendment was there that within 60 days, if the stakeholder has not given their claim, we have to admit this claim. But at that time, after expiry of the 60 days, the claim has not been admitted. Now, after expiry of 8 months, should we admit this claim or should we take the permission of AA?
So, ma'am, here, see, then now the provision clearly says that if, say, suppose there was a claim submitted during CIRP time and no fresh claim has been submitted during liquidation process, then the liquidator is required to admit the claim based on the claim submitted at CIRP time. Now, prior to introduction of this particular amendment to the regulation, wherein the liquidator is required to admit the claim submitted during CIRP process. If, say, suppose your liquidation process is already started, and before this introduction of this particular amendment, And at that time, you have not accepted the claim given that no fresh claim was submitted at the time of liquidation stage. In that circumstances, of course, you can give reference to the circular date that this circular has came after the initiation of this liquidation process and not beyond and not before that. And of course, after this process been commenced, the liquidator is entitled to accept the claim within a period of 30 days only. If at all the claim is filed beyond 30 days period, then the respective creditor has to approach to adjudicating authority under regulation 42 to get their claim accepted or condone the dealing with that regard.
Fine, ma'am. Thank you.
Ma'am,
So I'll be continuing.
clarification.
Yes,
Just little clarification on 53.
yes,
There are three creditors. One is two FCs, one OC. Two FCs, one NBFC, one FC related party, and other is OC government. How we will distribute the proceeds?
the first priority creditor will always include the financial creditors, operational creditor.
Including,
Whether the operational creditor
including
is holding
related
any
party.
secured. Sorry, sir?
Including related party. One is NBFC and other FC is a related party. Then
One is NBFC, the other one is related party. Okay.
NBFC, one NBFC, second related party FC, then third OC government. Three parties. How
And the government you are saying is you have already
GST
received a
department,
claim
GST
as a secured
department.
creditor?
No, GST department.
GST department. Okay.
Yes.
So there are no property attached. This government dues is not a secured creditor.
No.
So when the government dues is not in a secured creditors row, so of course they come in section 53(1)(e), which is about government dues in the hierarchy. So first payment, of course, has to be done to the financial creditor, the NBFC
Yes.
one, and
Yes.
then the subservient payment will be gone to the government dues, and then if at all anything is left, then the payment is to be made to the related parties.
Okay. Thank you so much.
So back to the PPT, which is about comparison between the resolution in CIRP and going concern in liquidation process. While, Shaivi, please, for the slide before this one. Yes. So the transfer of corporate debtor happens when it comes to resolution plan, because pursuant to resolution plan, I am selling the corporate debtor to the prospective buyer. The prospective buyer acquires the company. In case of going concern sale of corporate debtor, of course, the same thing happens, wherein you are selling the corporate debtor, entire corporate debtor as a going concern, and while selling this business of a corporate debtor, you are selling one or more undertaking of a corporate debtor to the prospective buyer. When it comes to share capital, in all the three aspects, the share capital, the existing share capital of the corporate debtor gets extinguished, and the new shares are to be issued in favor of the investor. So the reason behind this is always that the fund which was infused by the earlier promoter in the company the promoter will not be the promoter in the future as well, because the other person has come into the picture. So in order to give the recognition to the new investor, it is very much important to extinguish the earlier share capital of the company and get the new shares infused there. The liabilities,
Ma'am, a little clarification here. So far as listed companies are concerned, suppose take an example of Ruchi Soya. Okay, that company that the share capital was never eroded. The past members still continue to be the shareholder of the successful resolution applicant.
Sir, can you please just repeat the question once?
I said that you, as per the slides, share capital gets extinguished, right?
Yes.
In all these three kind of situations. Suppose prior to this, suppose these things like, section 12A application is there, and suppose there is a settlement, then the status quo of share capital will be maintained, isn't it?
Yes.
Okay.
If there
Now
is a status quo, then of course this has to be maintained till the time the status quo position is there.
Okay. Now let us go stay forward. So far as listed companies are concerned, okay, they're also that all the existing shares gets extinguished, right?
Yes.
Okay. So, but what happened in the Ruchi Soya case, where the past shareholders, they continue to be the shareholders of a new entity.
So, sir, in that case, you are talking about the public shareholding, which requires the minimum public shareholding in case of listed company, I believe.
Yes.
So minimum public shareholding requirement is still there in the provision. If you have seen the provisions of SEBI SAST provision, takeover regulation basically. So that regulation, of course, debars not require the particular prospective acquirer to make any open offer, etc. However, the provision with respect to maintaining the minimum public shareholding is still there. One still have to see that the minimum public shareholding has to be maintained. After acquisition, there is a time window provided that within this timeline, one has to see that the minimum public shareholding is there. If that is not there, in that case, the company has to be converted into unlisted companies.
No, but in that case, madam, so for my little knowledge, so far I can gather, because the entire share capital of the past members prior to CRP, like, it was converted, it was retained as it is in the new company acquired by the Patanjali, or thereafter, they have started uploading it.
Sir, I checked that once. I am not confirmed about this as to why and what was the reason to retain the same. However, I'll check that once and I'll get back to you on this particular question.
Okay, fine. Thank you.
So coming back to the PPT, so the liabilities, as I said, the liabilities get extinguished as the liquidators or the RP is required to provide the clean slate to the prospective buyer, and the burden of liability should not go with the prospective buyers. When it comes to management, the management changes once the new buyer is there, the new acquirer is there. Of course, the new buyer or new acquirer will want to change the management in accordance with their will, in accordance with their right, and of course, in line with the applicable rules and regulations. Next slide, please. So treatment of carry forward of losses. This is something which is very much concerned for all the professionals, and more than professional, it is more of a concern for the prospective buyers as to if at all they will get the benefit of carry forward of losses or not when it comes to going concern sale. Because the provision of income tax, etc., are clearly providing with respect to resolution process. All the provisions are dealing with the resolution process. However, none of the provisions as of now provides for the going concern treatment as to what if the corporate data is being sold in a going concern manner, whether at all the benefit will be given to the respective or the prospective buyers or not. In that regard, reference can be drawn to the respective rulings wherein adjudicating authority upon application by the successful buyer, the successful applicant or the acquirer, the adjudicating authority has granted certain relief to the buyers, of course, subject to the determination by the respective regulatory authorities. Then it comes to benefit under various SEBI regulations. When it comes to resolution process, the benefits under SEBI regulations for preferential issues or allotment of shares, substantial acquisition, etc., are available with a resolution plan approved by CIRP. These benefits are not available in case of going concern or sale of a business as a going concern process as of now. So treatment of assets and liabilities. When it comes to treatment of assets and liabilities, of course, the assets are getting recorded in the books, books of the corporate data after being acquired by the prospective buyer. But the liabilities, when it comes to liabilities, the liabilities are getting extinguished. The liabilities do not go with the corporate data, whether the corporate data is being sold as by way of a resolution plan or by way of a going concern sale, or a business is being sold as a going concern sale. Next slide, please. Now I'll be discussing regarding the relevant ruling with respect to treatment of claim under IBC. So Muzaviya Karamchari rule, one of the very recent ruling on Supreme Court, which has raised eyebrow of everybody, and finally the Supreme Court has also adjudicated on this workman's claim part. When it comes to workman's claim, this is very sensitive part, because workmen play a pivotal role during CIRP process, during liquidation process. So always concern arises as to what should be the treatment of workmen's dues. So when it comes to workmen's dues, the dues includes several components. Of course, the daily wages are there. Then the provident fund, gratuity fund, pension fund, other voluntary created funds are there. So how to make treatment and how to accept the claim, what should be the manner of treatment, etc., are always a concerned part. And you must have seen that in most of the liquidation process, undergoing as of now, this application or the concern with respect to treatment of dues of workmen and employees have already been always been discussed and always been a part of the lengthy proceedings. So when it comes to workmen dues, first of all, the section 36 subsection 4, which clearly says that the fund, the provident fund, pension fund, and gratuity fund are out of the liquidation estate. Out of the liquidation estate means on this particular funds which are created, liquidator do not have any say. Do not have any say as in liquidator do not have a right to have any kind of interference with respect to determining the amount of claim, with respect to using the amount which is available in this fund. So this fund are completely outside the jurisdiction of the liquidator, and liquidator has no right to touch upon these particular fund. Now, what if there are no fund? If there are no fund, in that case, the payment has to be done in by way of through the liquidation estate in the manner provided in 53. What if, say, suppose the as per section, what if there is a fund but there is a shortfall in the fund? So the amount is there in the fund, but the amount is not sufficient enough to make payment to the respective dues of the workmen towards the gratuity, provident, and pension fund. In that case, up to the amount which is available, a payment will be done. The amount which is shortfall, the payment has to be done in terms of 53, the hierarchy which is provided in 53. This Moser-Beer-Kanchari ruling, in this particular ruling, the Supreme Court has held that waterfall mechanism under 53 is based on a mathematical formula, and any interference with the same could disrupt the function of the code. Hence, the court has held that distribution of assets must be made in terms of 53, read with section 36(4). That is to say, section 36(4) has to be established. The funds, etc., has to be treated in terms of 36(4), but the claim, the particular claim of the respective workmen with respect to their salaries, their bonuses, etc., has to be treated in terms of 53 only. There, the reference of Companies Act is also given, wherein section 326 of Companies Act has been given to determine as to what all includes within the purview of the workmen dues. Here, the bench has, the Supreme Court has also said that when it comes to CIRP dues, one has to see that whether the entity was working during the CIRP and whether those workmen were also included and were also working during the CIRP. Because what happens, say suppose at the time of CIRP or at the time of liquidation, the entity is already shut. So there is no operation in the entity. Can the workman come and say that make my payment towards those time as well when the entity was shut? So say suppose, I'm giving an example, say suppose the entity, the factories of a corporate debtor were shut in 2015. And the liquidation process of the corporate debtor has initiated in 2017. For this 2-year timeline, there were no business at all. There were the factories were completely shut, and none of the workmen were engaged for the work during this 2-year timeline. Now, when it comes to section 53 priority, the first priority creator says that the payment has to be made in line with the payment or at par with the payment to the secured creditor. So can the workman come and say that for this 24 months, which was just before the liquidation commencement date, during which the plant was actually shut, you are required to make my payment? Here the concern arises as to when the factory was shut, how can I make payment? The factory was shut, there were no operations, you were not engaged at that time. How can you ask for payment for that particular time? So this concern has not yet been raised in a particular issues, has not been discussed in a particular issues with respect in line with the liquidation process, and is yet to be seen the light of the day pursuant to the adjudication or pursuant to the rulings to be held by the Supreme Court, of course, in a future prospect. Shaivi, next slide, please. Treatment of secured and unsecured creditors claim. There are Supreme Court's ruling in case of Jitendra Nath Singh versus official liquidator, where it was held that secured creditor has only a right over particular property offered to him as a security, and all the creditors have equal rights over the other properties comprising the estate of the person adjudged insolvent. That is to say, If say suppose I am a secured creditor and I am intending to realize my security interest, so I can realize a security interest only to the extent of assets that I hold. Only when the asset is going into the common pool, I have a right of receiving the distribution, the part of distribution as the other secured creditors are getting. The second one, which is about JM Financial Assets Reconstruction Company, wherein incl has held that the liquidator finds out as to who has the first charge on secured assets from the records maintained by the information utility or by such other manner as may be prescribed, and pass the appropriate order. Why it has been said so? Because the liquidator has right to adjudicate the claim. Shaivi, you can move on to the next slide. So the liquidator has right to adjudicate the claim. The right available with the IRP or RP, but is available with the liquidator. So liquidator has right to adjudicate the claim, whether the claim is to be admitted, whether the claim is to be rejected. If the claim is rejected, then of course the respective creditor has always this window open to approach the adjudicating authority with respect to determination of their claim. When it comes to position of an operational creditor, claims up to the initiation of CIRP, the tax dues, etc., are a part of are also a part of government dues. In this case, Ghanshyam Mishra ruling is there. Then Akshay Jhunjhunwala ruling is there. When it has been held, then operational creditor will also include a claim of a statutory authority on account of money receivable pursuant to a imposition of a statute. When it comes to Supreme Court ruling, as we were just discussing regarding the Rainbow Papers ruling, that sir has asked about my views as to what I think about the state government's dues. So as I said, that I cannot go beyond what has already been held by the Honorable Supreme Court. And while there are discussion paper which are questioning on this Supreme Court ruling and are of course looking for the relevant prospect or relevant approaches to be seen from the IBC's perspective. However, amendments in that regard is yet to be given by the IBBI. In any case, section 238 is there, which are always given overriding effect over anything which is contrary. When it comes to income tax determination, Monad's path ruling is there. Monad's path ruling by the Supreme Court, which says that IBC will supersede over income tax matter as well, income tax law as well. So of course, one has to see in line with the Monad's path ruling as to whether while determining the claim with respect to income tax dues. With respect to the other statutory dues, there are rulings of Bikabai. There are rulings of Monad's path, as I already said. Then the rulings of Leo edible oil, which is also very important ruling, wherein with respect to tax dues, it was held that being an input to consolidated fund of India and of the state clearly comes to the ambit of section 53(1)(e) of the code, and income tax department, not being a secured creditor, must necessarily take recourse to the distribution of the liquidation state in terms of section 53 only. Shall we go to the next slide, please? Claims of guarantor, one of the very, very important ruling. So along in this particular part, I would like to discuss upon the principle of subrogation, which is very important. So when it comes to principle of subrogation, let us first understand as to what this subrogation is all about. Just a second. So subrogation is something that allows one person to assume the right or remedy of a creditor against a debtor. When it happens, when say suppose I'm a guarantor and I have paid the entire due of the principal debt, entire obligation of the principal debt. In that case, I step into the shoes of the respective creditor and I stand in the queue with the other creditor with respect to my dues. This particular principle of subrogation is provided in Indian Contract Act, section 140 and 141 of the Indian Contract Act. This particular section deals with the principle of subrogation with respect to the rights of a surety or guarantor. This provision says that if the debt guaranteed by surety becomes due, or if the principal debtor fails to perform the guaranteed duty, the surety upon payment or performance of guaranteed debt is entitled to all the rights which are available to the other creditors against the principal debtor. Now the question comes whether the same right is available in case of IBC proceeding as well. Whether one can take reference of this particular section of Indian Contract Act when it comes to IBC proceeding. Under Insolvency and Bankruptcy Code, personal guarantors are liable through a notification which came in November 15, 2019. Since then, the rights and liabilities under IBC have been debated in various legal forums. The treatment of corporate guarantor under IBC, this differs from the established principle of contract of guarantee under Indian Contract Act, of course. The rights of subrogation, which is an essential part of a contract of guarantee, has been a subject of discussion when it comes to IBC process. This right allows the guarantor to step into the shoes of a creditor and recover the amount from the principal debtor. But in the rulings, especially in Lalit Mishra ruling, Lalit Mishra versus Sharon Biomedicine, incl has held that if this particular ground will apply when it comes to adjudication of claim filed by the principal guarantor, by the personal guarantor on the basis of this right of subrogation, this would defeat the very purpose of CIRP by restarting the cycle of non-payment or default or recovery and putting the stress on the company's asset. Hence, it was ruled that guarantor cannot exercise their right of subrogation under Indian Contract Act when it comes to IBC proceeding. This is also supported by Section 238 of Insolvency and Bankruptcy Code, which says that this provision will override over any of the proceeding, any other law which is contrary to the provision of IBC. There are also several rulings, for example, in SR Steel matter versus Satish Gupta, wherein Supreme Court has denied a claim for reimbursement from the resolution applicant by a guarantor. When the guarantor has paid the dues and asked for payment of dues, in that case, the Supreme Court has denied that guarantor cannot claim the right from the resolution applicant. So idea behind the same is that first, of course, when it comes to Section 140, one has to see the actual language of the section, which says that entire due has to be paid. So if, say, suppose the total due is of 100 crores and the guarantor pays, say, suppose 5 crore or 10 crore of the dues and ask for the repayment or ask for the payment with respect to the 5 or 10 crores that were paid by the guarantor with respect to the dues of principal debtor, can the guarantor stand in queue and ask that pay my 10 crore for this 10 crore rupees, I am your creditor? The answer is no. First, the thing is that the liability of guarantor is coextensive with that of the principal debtor. It is established principle. So the guarantor is liable not only for that 10 crore which has already been paid by him. The guarantor is also liable for the remaining amount of 90 crores, because the provision now requires, or there are established regulation, rulings which now says that a proceeding can be initiated against personal guarantor without initiating proceeding against the principal borrower. So being a creditor, I have a right to initiate the proceeding against the personal guarantor without initiating any proceedings against the corporate debtor. So if I'm initiating a proceedings against the corporate debtor, against the personal guarantor, I have a right to initiate the personal guarantee for the entire amount for which the personal guarantee was given. And if, say, suppose the guarantee was given on entire 100 crore rupees and the creditor is paid for 10 crores only, so the creditor cannot come for that 10 crore rupees because he is still liable for the remaining 90 crore dues. And here the rule against double proof also comes into the picture, which says that for same amount, two creditors cannot stand and cannot ask for their claim. So for same amount of dues, if, say, suppose a personal guarantor is also coming in queue and asking for the 10 crore of payment, then the creditor is also there who's asking for the 90 crores of amount. So for this 100 crore amount, there will be two creditors. One will be the the personal guarantor who has paid dues on behalf of the corporate debtor, and the other one is the main creditor. So there cannot be two creditors for the same amount of dues, and hence this Lalit Mishra rulings prevail when it comes to claim of a personal guarantor. Moving on to the next part, which is about the need of legislative amendments There are discussion paper, as I said, pursuant to these rulings of Supreme Court in the matter of rainbow papers and the other rulings. There were several concerns that have arisen with respect to adjudication of claim, with respect to treatment of security interest, etc. And there are still the provisions, as we all know, that IBC provisions are evolving and yet evolving, and there are still scope of several developments on this particular provisions of insolvency and bankruptcy code, given the practical aspects involved therein. Because this entire code, to the extent is provided in rules and regulation, is beyond that something which is relating to the practical applicability. The more cases are getting admitted, the more different types of concerns are getting raised as to what if this has happened, what if the particular thing has not been happened. So several concerns are arising with the admissibility of respective cases, and the law is still at an evolving stage. And IBBI, of course, in line with the requirement of the Act, in line with the requirement based on the judicial proceedings, are making changes in the code and in the liquidation regulations and CIRP regulations from time to time. So there are still window which requires concerns, or which requires to be dealt with by the IBBI, such as first is about unsecured creditor, wherein other than the workmen or employees shall be treated equally for the distribution under 53. So what will happen to the operational when the recoveries made by the operational creditors are inadequate? Then the clarification treatment with respect to security interest created by statute to nullify the effect of Rainbow Papers Limited. This concern has also been raised. Then there are other concerns as well. Secured creditors' right to either realize the security interest or relinquish it within the given period. Only the 30 days period is given, but still there are cases wherein the secured creditors are holding the assets and not ready to release the assets, and the IRP or RP are facing difficulties when it comes to realizing the assets. Because unless the IRP, RP or the liquidator are holding the assets, are having the rights on the particular assets, they cannot take the further actions to realize the assets, or to acquire ask the prospect acquirer to sell something. Because say, for an example, if you are selling an asset, you are selling a property. So until unless you have all the documents of the property with you, all the concerns of the property with you, all the rights about the property with you, how can you sell the property for? So for the purpose of acquiring the rights, for the purpose of having the entire hand holding on this asset, you have to have the assets under your control so that you can see the future prospect on that particular asset part. Shaivi, is there any other slides remaining? Okay, contingent claim part that I was discussing, and of course there were concern with respect to the contingent claim pass as to what will happen when there are contingency in the claim, whether contingent claim also forms part of a claim, and if they are forming part of the claim, whether these contingent claim will be, the creditors of contingent claim will be treated as creditor and should be admitted in the COC forum or not. So these are certain questions that were raised during the session. So I'll just deal with this part, that contingent claim is a topic which is a word which is not particularly included in the definition of claim. The definition of claim which is provided in the code does not include the contingent claim within its ambit per se or specifically. However, there are rulings which has established that contingent claims are also a claim and should be admitted by the respective IRP, RP or liquidator based on the contingency involved. When it comes to contingency involved, of course, when it comes for the funded part, for the crystallized part, the payment is already there. It is easy for the respective IRP, RP or the liquidator to determine as to how the claim has to be treated. The concern arises with respect to the unfunded exposure when the fund is not there. So in that case, with respect to the claim filed by the creditor with respect to this unfunded exposure, the amount of unfunded exposure, to the extent the same remains outstanding, that will be treated as contingent claim. As and when during the conduct of CRB process or liquidation process, as the case may be, this unfunded exposure expires or are no longer payable by the particular financial creditor, the amount thereof shall be reduced by the amount of the unfunded exposure. In case, say suppose during the conduct of the CRP or liquidation process, the unfunded exposure devolves or is converted to a funded exposure, in that case, the same shall be immediately recognized as ordinary claim. And as per and after determining it as an ordinary claim, the same treatment has to be done as you are treating to the other claims or other creditors. When the treatment with respect to this contingent claim during CIRP or during liquidation process concerns. So during CIRP process, how to treat these claims? If during CIRP process, the exposure becomes funded, means in that case, say, for instance, say suppose on account of invocation of guarantee, the IRP, RP or the liquidator, what is to be done at the time of CIRP? So when it comes to invocation of guarantee, in that case, the claim has to be modified by the IRP or RP, and there will be modification in the committee of creditors as well, the list of stakeholders as well, and thereby including the funded exposure as a part of the claim. The funded exposure will form part of the respective claim. The details of contingent claim, which is admitted, that should obviously form part of the information memorandum as well. Then the rights of that creditor, that shall be determined accordingly. We are of the view that concerned creditors may be included in the committee of creditors to the extent the estimated value of contingent claim is determined. Where the contingent claim fructifies, in that case, say suppose the contingent claim is getting fructified during the liquidation process. In that case, payment to the creditor under resolution plan will be proportional in accordance with the plan. And if the contingent claim does not result a debt, it is not converted into a debt, then there is no question of any payment. So whether the contingent claim is getting converted into a debt or not is a question, is a concern. If the contingent claim is converted into a debt, in that case, the question of payment comes. When the claim is not getting converted, the question of payment does not come into the picture. Similarly, at the time of liquidation process, the liquidator has to make the distribution based on the amount which is admitted. If say suppose there is no, the amount is not yet been admitted, then the question of making any payment does not arise. For unfunded exposure, of course, there always remain a question till the time the unfunded part is getting crystallized and getting funded. So till the time the fund is not included therein, then the question of making any payment pursuant to the liquidation proceedings does not arise. However, when this amount, this unfunded part turn into a funded part, then liquidator has to give equitable treatment to this creditor as well in line with the other creditor. So this is about the
yes,
treatment.
madam, let us throw some light on, like, I have received a claim which is contingent in nature. The first of all, that IRP duties to recognize that particular claim, whether it's a contingent or what is the nature of the claim. Now the next question comes, like, suppose I have received a claim which is contingent in nature. So I have to, first of all, I have to recognize, I have to minutize it, that I have to tell the COC that I have received this much, and that is going to be a form part of IM, right?
Yes,
Okay.
absolutely.
Now the second part comes, like, once I have recognized, whether I should put that particular creditor in the COC if it is not funded, if it is not crystallized.
As I already answered your question before, sir, until unless it is crystallized, this will not be included in the COC list.
Great.
The COC, for including the particular creditor in the COC list, the exposure has to be converted into funded part. Till
That
the
means
time
it
the
has to be-
contingency is involved, the particular creditor cannot be treated as a part of the COC member.
Okay, only the good way of practice, or, like, prudence way of practice, is to minutize that, okay, this much amount has been received, which is
Of
under
course,
verification.
minutization is important, and of course, say suppose at the time of initiation of CIRP, that part is contingent. However, during the CIRP process, the contingency goes away, or the unfunded exposure turns into a funded exposure. So in that case, of course, you have a right to admit the claim and to give the particular creditor right as the right as available to the other COC members. So this window is always there. But for the creation of COC, you have a window within which you have to create the COC. 23 days is there within which you have to create the COC. So at the time of COC, if the particular creditor is contingent, you cannot treat the particular creditor as a part of the COC member and has to accordingly minutize the same. I hope I'm clear, sir.
Yes, yes, very much.
Hello, ma'am.
Yes, sir.
Hello, one
Yes, sir,
query
yes, sir.
here. Yeah, can the financial creditor go after the ex-directors for the haircut they were given to the corporate debtor?
So for, as I already said this part, that the proceeding under CIRP process or liquidation process is giving a go away to the company and not to the directors. So directors are still liable for their conduct.
Even for
or
the
misconduct.
financial creditor? Even
Yes,
for the
yes,
financial
for
creditor?
everybody. For financial creditor,
Okay.
says under financial, when it comes to financial creditor, during the CIRP process or pursuant to the liquidation process, the financial creditor is getting a part of their exposure that they have given to the particular company. What about the remaining claims? They have to take the haircut therein, but it is always open for the particular creditor to initiate proceeding against the personal guarantor or to initiate proceeding against the erstwhile directors, etc. So that window is always open for the respective creditors. However, you cannot go to the respective acquirer and ask for the claim. The acquirer is not responsible for any dues or any part which is undone or which is not paid.
Barsha, one question.
Yes.
What happens when there is an IBC proceedings? There could be good chance that in a group there are numerous entities, and a few of them are interconnected, and all of them goes into the IBC proceedings. So say company number 1 in the group goes for the IBC proceedings, and there is a resolution plan which is in place. Company number 2 also gets into, and the resolution plan is still time to go, but IRP has been appointed. Now company number 1, since the resolution plan is pending for approval at the NCLT, say it is pending before the NCLT, the IRP makes a claim for the outstanding amount with the company number IRP of company number 2. Now, what would be the status of that claim which he makes with the company IRP of company number 2?
So I'm just repeating the question that you have said, sir, that as an IRP, of course, I have a duty to realize the assets of the corporate debtor. So to the extent the companies are interconnected and there are certain dues that are there for the company 1 from the company 2, for which the IRP has filed a claim and company 2 is still undergoing the CIRP process. Is that the concern?
Correct.
The company 2 is still undergoing the CIRP process and my company is also undergoing the CIRP process.
Yes.
The resolution process has not yet been completed. Is that the concern, sir?
Correct. But both are at different stages. One is at the stage where the resolution plan has not been approved by the COC. However, for the company number 1, which is making a claim on with the IRP number 2 of the company number 2, that company has got the resolution plan which is approved by the COC and is pending before the NCLT.
So first thing is, sir, when the resolution plan is already approved by the COC, then there is no question of admitting any further claims by the respective IRP or RP. However, when it comes to realization of assets of the corporate debtor, so of course it is one of the duties of the IRP or RP to realize the assets of the corporate debtor. But say suppose during the process, the claim is yet to be fructified or yet to be realized. In that condition, what are the options available with the IRP or RP is to make a disclosure with respect to that particular aspect in the information memorandum. Because if my resolution plan is yet to be approved, of course, there are aspects for the prospective resolution applicant to think through regarding this particular claim as well. Because this is one of my claim for which I may get something in future. So that part has to be involved in the information memorandum.
I beg your pardon. The idea is the company number 1 is at the stage before the NCLT. The resolution plan for company number 1 is before the NCLT, whereas the resolution, the company number 2 is under the CIRP process. So IRP of company number 1 has made a claim with IRP of company number 2 for the outstanding amount. So that company is still not the company number 2 has not filed has not received the resolution plan yet.
So I am explaining that part only. That if say suppose I have a claim, I am a company, I have a claim against the second company. Okay. So this claim is indirectly my asset only. I may or may not get realized something in future from this, but there are of course a possibility that I may realize something from this. Whatever I'll realize goes to whom? Goes to the prospective buyer, prospective acquirer. He will have the right and he will claim the right ultimately. Or if say suppose I do not initiate any proceedings and that proceeding forms part of my information memorandum only, that these are the cases which are pending and you have the right to proceed ahead or continue against these particular proceedings.
Memorandum is no more there because I've already filed the resolution plan. And
So
that
before filing the resolution plan, I'm saying that before filing the resolution plan, this was certainly in your knowledge only that this kind of claim is also there.
no, so
But-
that time say the company was not under the company number 2 was not under the CIRP. It came to his knowledge only after filing of the resolution plan with the NCLT.
Sir, company number 2 is undergoing CIRP or not, that is not my concern. Why so? Because if say suppose the company is not undergoing CIRP process, company number 2 is not going CIRP process, still I have a right to pursue for my claim against the corporate debtor. I can ask the management of the corporate debtor to make payment towards my dues, right? So in that case, this particular determination that I have a right to realize this much of amount from this particular creditor is still there. So either I will realize or I will say the respective resolution applicant that if I have not realized, I am giving you the right to step into my shoes and realize once you are getting into my shoes as a resolution applicant, post approval of the resolution plan by the adjudicating authority.
Correct. But what my question is that while this my resolution plan for company number 1 is pending before the NCLT, I came to the knowledge that company number 2 is under the CIRP process and resolution plan has not been filed. I can still file my claim before the IRP of the company number 2. And I filed my claim with IRP of a company number 2. Then what would be the status of that particular claim before the IRP of company?
So you have just filed the claim, sir. It is not even crystallized as yet. You may or may not get anything. So this will be a contingent claim only. And once the resolution plan approves, then of course it will be treated at par with the other claims. It goes up.
No, technically I'm a financial creditor for a company number 2.
Technically, sir, you are, but still it is under contingency, no? You are claiming something.
I may not realize, but what I'm asking is what will be the treatment in the treatment by IRP number 2 for the company number 2, IRP of company number 2? Will he take me as a related party, or he will say no, you are no more a related party, and hence you are there, and as and when the resolution plan comes up, we will take it accordingly?
Sir, in that case, one has to see as to at initial stage and on what particular definition of Companies Act or Ind AS as will be applicable, that company was a related party to the main entity. If the very relation goes away, then the concerns of related party transaction goes away itself. If say suppose pursuant to a common directorship, the related party came into the picture and the directors are not there, then the other party is not a related party. And the provisions of related party will not be attracted in this particular case. So the treatment like any other creditors has to be given in the case of, in my case as well, by the respective resolution applicant in case of company 2.
Okay.
Ma'am, I think that his question, just to elaborate and just with due respect, his question would be more like, what is the status of his claim? But natural, being a related party, he would be invited in that COC meeting, but having no right of vote or no participation in the meeting.
Of course, till the time the amount is getting crystallized, the participation right does not come. The participation rights only come when the payment is crystallized and it is clear with respect to the claims of the respective creditor.
No,
So for
claim
this-
is, madam, claim is crystallized. The question is that the treatment of a related party in the COC
So
meeting.
again, as I said, sir, on what basis the party was related party? When the relation goes, if I am saying that I am a relative of yours, I am a related party of yours, pursuant to certain, connection between the promoters or directors or something, because under Companies Act, under LODR regulation, under Ind AS provision, the definition of related party is vast. So one has to see as to on what basis the companies were treating each other as a related party. If the very relation goes away, then there is no question of treating the entity as a related party. If the
Madam,
relation still continues,
madam, at what stage the relationship will go away? Because
after the approval of the resolution plan, when the third party comes into the picture. Till the time I am into the picture, the resolution, the third party is not into the picture, then I'm still your relative.
that means change of management will, discard me as in the category of related party. You mean to say that? Or
that again comes to the concern, sir, on what basis the companies were related party. If it was holding subsidiary relationship, it was a joint venture relationship.
Okay, let's take an example. Ma'am, let's take an example. It was a holding and subsidiary company relationship. It is well established.
Well established. If at all pursuant to the acquisition by the new management, whether at all that company will still be the holding company or the subsidiary company. If
no,
the relation will still be there, then the company will be treated as related party. If the relation is not there, the company will not be treated as a related party. And of course, the window for modification at a substantial stage is always open for the respective resolution applicant.
Please proceed, ma'am.
Yes. So regarding this contingent claim part, I have discussed. Shall we please move on to the next slide? This rule of double proof also I have discussed in a short, brief manner regarding this particular rules against the double proof, which is also related to the personal guarantor only, wherein I say that the principle of subrogation, pursuant to principle of subrogation, there are windows pursuant to which the personal guarantor may come into the steps in the shoes of a creditor. However, also the rule against double proof is there, which says that which actually prevents two or more claim with respect to the same debt. So for a same debt, two creditors cannot come. So if a guarantor is paying the debt, the guarantor is required to pay the entire debt and cannot just make a part payment towards the debt and stand in queue and say that you are required to make payment to me as I have paid a part payment on your behalf, because the guarantee was given on behalf of the entire claim and not for a particular part of the claim. So until unless the entire liability, entire obligation is being paid, the particular creditor cannot, the particular personal guarantor cannot come and say that they step into the shoes of a creditor. So in this regard, if we see the Contract Act, Indian Contract Act, that also says that until unless entire liability is paid, all the liability is paid. This all the liability one has to emphasize on while determining the position of a personal guarantor.
That means combination is possible, madam. That means the combination is possible. 10 the personal guarantor has paid and 90 corporate debtor.
No, that is what I'm saying. That says, suppose if the personal guarantor has given guarantee, I have taken a loan of 100 crores and personal guarantor has given guarantee. But the personal guarantor eventually, pursuant to invocation of pledge or something, pays towards 10 crore only. Can the personal guarantor come and say that I am a creditor to you for this 10 crore amount? The answer is no, because the guarantee was given for the entire debt. And the guarantee of the creditor is coextensive with that of the principal debtor. It is established principle. Hence,
so suppose the 90 pays from the other side, the principal borrower, then there is no liability in existence. Similar
case will be there. That for one claim, there cannot be two creditors. So the creditor is also there, and the principal debtor or the personal guarantor is also coming for the same claim. This cannot happen. So until unless the entire payment is done. So one has to see whether all the entire payment is done or not. If say
madam, entire payment could be in either form, either the principal debtor or the corporate guarantor or personal guarantor.
When the principal debtor pays the entire sum, then the question of giving any guarantee by the personal guarantor does not come into the picture only, sir. The very reason of guarantee is that if the principal debtor unable to pay, in that case, I'll come into the picture and I'll make payment towards the dues. However, if the principal debtor pays, can he come and say that now you have given the guarantee, you pay me? He has given guarantee for my performance only, for my dues only. So principal debtor cannot stand in queue and ask for payment against the personal guarantor. However, of course, personal guarantor may have subject to entire payment of the dues.
Mhm.
Madam, just one small question. Is a guarantor also covered under disqualification under 29A?
Sir, can you please just be a bit louder, sir?
Is the guarantor also covered under the disqualification under 29A, sir, madam?
29A. 29A, sir, you are saying with respect to eligibility of the prospective acquirer.
Correct.
So guarantor is staying with my parlance. If I am not able to make payment, then guarantor will have to make payment. How can guarantor come into the picture of the acquirer and ask for acquisition of my asset?
No, is a guarantor also?
There is no question of the guarantor coming into the queue with the prospective acquirer, sir. The guarantor is liable for my debts. If I am not able to pay, then guarantor has to pay. How can guarantor come in and stand in queue with the prospective acquirers?
No, can he become an acquirer is what I'm asking.
That is what
He
I'm
will say,
saying,
okay,
sir. How can a
I'll
guarantor
honor-
becomes the acquirer?
He will say, I'll fulfill my responsibility, but I will acquire a company.
Well, I'm not aware of any such particular rulings in that. For sure, the code and regulation does not provide anything in this regard. And I am not so far as come across with any such ruling dealings with this kind of case that guarantor comes and stand in queue with the acquirer, and accordingly the resolution applicant or the liquidator has to establish the eligibility under 29A with respect to the guarantor. This I have not come across till now, sir. But if at all
This was
I'll
an
see
academic
anything in
thing.
that regard, I'll surely get back to you on
Thanks.
this. Shaivi, is there any remaining slides there? So I think we are done with the today's session. So now I'll request the respective participants to ask questions.
Madam, the personal guarantee matter is still sub judice or?
Sir, the proceeding against personal guarantor can be started. There are rulings which says that the corporate, without going for initiation of CIRP proceedings against the corporate debtor, you have the right to initiate the proceedings against the corporate against the corporate guarantor or the personal guarantor. Yes, you don't have to go for the corporate, the principal debtor first, and to go for the respective personal guarantor subsequently. So this ruling is already established. Then now proceedings against personal guarantor can be initiated.
But I think it is stayed by the Supreme Court or it is under some review.
So there are
Any-
Court rulings. There are Supreme Court rulings on this. I'll just give you reference of those.
Mr. Jain, I think. In the Anil Ambani case.
Anil Ambani case, I'm not aware of, but yes, there are rulings. I'm giving reference.
It's Gurmeet Singh Sodhi. It's still pending in Supreme Court.
Which one, ma'am?
Gurmeet Singh Sodhi, I suppose.
No, there are other rulings as well. I'll just give reference. If you can please allow me 1 minute, I'll just check and give reference.
But according to me, I think cases are being taken up in NCLT, and if a writ petition is filed in Supreme Court, then only the stay is granted.
Sorry, ma'am.
Means the matters are regarding personal guarantors, matters are being taken up in NCLT. However, if the personal guarantor files a writ petition in Supreme Court, then it is being stayed. The matters are stayed.
Yes, it will be tagged once the final verdict comes into
Well, tag
the
along right
finality.
is always there, sir. You must have seen the future retail case as well. In the future retail case as well, this tag along thing was there. And apart from that, there are several rulings wherein, this tag along things have been taken into consideration, wherein the proceedings, there are no two separate proceedings are going on. And there were applications to tag along the proceedings against the personal guarantor and against the corporate debtor.
Madam, that initiation is allowed, but the matter is not moving forward. No, based on certain writ petition filed in the Supreme Court.
So that I have to check the current status.
Okay.
No, basically it would depend on case to case.
Of course.
Yes.
Rightly said by ma'am, that it depends upon the case to case. And as I said at the very beginning of my session itself, that IBC is such a law which is evolving based on the case itself. So the more cases are getting admitted, the new scenarios are coming into the picture, and based on that, IBBI is also making amendments in the rulings, making amendments in the provisions, making discussion paper open for the IRPs, RPs to make their suggestion or give their suggestion with respect to the changes based on the practical difficulties that they are facing. So the law is, of course, still evolving and requires certain clarifications still. I think this 10-15 minutes time I still have, so I would quickly like to cover the voluntary liquidation part as well.
Just 1 minute, one question, ma'am.
Yes.
When there are different types of cases pending against the CD, like TAT case, civil cases, investigation against the CD by CBI, ROC, EDs, SEBI, etc., how the IRP and RP or liquidator will deal with these cases?
Based on the latest latest ruling passed by the respective judges. Sir. First, of course, one has to consider the rules, regulations. If, say, suppose rules, regulations, and discussion papers are not clear enough to provide the guidance to the respective IRP or RP, then, of course, reference has to be drawn from the respective rulings, prevailing rulings which are there, and the decision has to be recorded. It is very important for the IRP, RP, or for the liquidator to record the decision. If at all, some contrary decisions are also taken, then also the IRP, RP, or liquidator should record the decision as to on what basis the decision has been taken. So here, of course, I would like to give some practical guidance based on the cases that we have faced so far. For the easy and smooth running of the CIRP process or liquidation process, what is the best way to accept the claim or to take note of the claim is to maintain a running Excel sheet. In an Excel sheet, the IRP or RP at the initial stage, at the CIRP stage, should keep details of the entire claim. Of course, bifurcation between the financial creditor, operational creditor, workman's dues, and operational dues, giving name, address, contact details of the respective persons, then the amount of claim, the amount that the respective creditor has claimed, the documents that the respective creditor has submitted for proving the claim, the amount which has been verified and admitted by the respective IRP and RP. If any contingency is involved, then the contingencies column should also be there, and the ultimate amount, which is whether accepted, whether not accepted, or whether it's still under contingent, whether pursuant to some judicial proceeding the amount has been considered. So that reference should be given. And as and when there will be any modification, subsequent Excel sheet should be inserted, subsequent rows should be inserted therein to make changes without making any changes in the previous rows or the previous Excel that was maintained by the IRP or RP. Because now, as we all are aware, that the regulation requires the liquidator to first see whether the claim was admitted by the IRP or RP or not. So, of course, it is a duty of the IRP and RP to hand over the claims in such a manner that it will become easier for the liquidator to determine the respective claims at the time of liquidation. Of course, during CIRP, the window is too small to verify the claim. So it is only a 7 days time which is given for the IRP and RP to verify the claim. But even if in the 7 days time period, the IRP and RP maintains this Excel sheet, it will be helpful for the respective RP if, say, suppose any concerns arises at a future stage of CIRP with respect to determination of claim, and of course for the liquidator as well at the time of adjudication of this claim during liquidation process. It will be easier for the liquidator to see through as to whether the particular creditor has filed the claim during CIRP or not, on what basis the claim was accepted at that time, whether any modification is required therein or not. So it will be very helpful for the respective liquidator to come into the picture and to carry forward the duties which were done by the earlier IRP or RP. So this is one of the suggestions that IRP and RPs, I believe that all the participants herein are mostly IRP or RP. So it will be easier for the respective IRP and RP. If say suppose the IRP or RP is getting, inducted as a liquidator or getting appointed as a liquidator at the time of liquidation as well. So it will be easier for the IRP to continue. And if say suppose some new liquidator comes into the picture, so we are, giving our hand to the other professional friend to continue with the liquidation process in a smooth and timely manner. So it will be, this is one of the suggestions to make this kind of Excel sheet with respect to admission of claims.
My question is, madam, if there is a dispute, civil dispute on the property of the CD, so how the IRP or RP will deal with that property or that case, civil case?
See,
or any type of case like a DRT case, civil investigation by CBI, how which is against the CD, how the RP or IRP or liquidator deal with them?
so sir, as you are aware that regulation, that section 14 of the code gives a complete stay on any continuation of proceedings against the corporate debtor during that moratorium period. So once the moratorium established, one IRP and RP has to approach to the respective appellate tribunal or the respective judicial, quasi-judicial bodies within whose jurisdiction the contingency with respect to the properties is going on, to ascertain as to what extent the right of corporate debtor can be established on that particular asset, because there may or may not be a right of the corporate debtor on that property, because of which the contingency has arisen. Say suppose in past some of the directors have already sold the property, and now because of that only the contingency or the appeal or the adjudication is going on before the respective forum. So IRP or RP cannot claim a right on a particular asset which has already been sold and which is not within the jurisdiction of the corporate debtor or within the jurisdiction of IRP or RP. So one has to establish as to on what basis or what was the ground on which the appeal or adjudication or the proceeding is going on before the respective regulatory authorities. And if it is determined that of course the right is there of the corporate debtor, then it is always open for the IRP and RP to approach the NCLT, because NCLT is the ultimate forum when it comes to IBC process to determine the status of the corporate debtor along with the corporate debtor to the assets which are connected to the corporate debtor as well.
Then what will be the status of that case? Suppose one civil case has been pending on the title of the property. So when the IRP or RP is appointed, what he will do with that civil case?
So I'll give a practical
Yes.
answer to this. The practical answer to this would be, sir, to invite the expression of interest along with the contingency involved therein. That this is a property which is going on, which is before this particular regulatory authorities or before this quasi-judicial or judicial authority, and the applicants who are interested to pursue this proceedings after acquisition of the assets may come into the picture and may bid for the prices. So of course, there are several cases involved wherein the prospective acquirers have come into the picture, have come forward to acquire such properties to which they think that they can deal in a better manner, because there are a huge number of creditors or the such number of acquirers who have better hand holding on the liquidation on the judicial proceedings, have a better outreach to the lawyers, better outreach to the judicial forums, etc. So they may come into the picture and say that this property I am interested, I am ready to buy this property along with the contingency involved, and I am ready to pay this much of amount to you. If that is acceptable to you, of course, you can accept the claim, and either by way of an e-auction or by way of a private sale, as maybe deemed fit for the beneficial liquidation of the process, you may proceed ahead with selling the assets along with the contingency. And if the prospective buyer is ready to take the assets to along with the contingency and gives you the payment, the ultimate remedy that you have is to make distribution of the realized process, whatsoever you have realized to the among the creditors involved.
Now, how we deal with that civil case? My question is, since the case is pending, what he will do? That RP, what he will do dealing with that case only, that civil case? We
So
will
first
leave
of
it
all, the
depend
IRP or
whether he will
RP
go
should-
to the court. Whether
Sir,
he will go to the civil court.
I'll answer to this question, sir. First of all, the IRP and RP should go to the creditors for whom you are fighting. So first of all, you have to place this issue before the creditors, that this is the situation, this is the asset, and should I continue with the litigation proceeding, or should I sell the assets in whatever or position it is? Because if you are going for the litigation proceeding, the money that you will use for the litigation or continuing with the litigation will be the money of the creditors ultimately.
Yes.
So first you have to take permission of the creditor as to what should you do. And if the creditor agrees that you go on with the litigation, then you go on with the litigation. If the creditor says that no, don't go on with the liquidation, but you try to sell the assets, you try to sell the assets in the manner whatsoever is available. If say suppose the assets are not in any manner is not, you're not able to sell, you can request the creditors if they have any buyers in their hand, or if they have certain assumptions that this particular person will buy, then they can come up with.
How can I sell that product? How can I sell that property when the case is pending in the civil court?
Yes. So there are several cases wherein the assets which is undergoing adjudication, which is undergoing proceedings before the civil authority, etc., are being acquired by the prospective buyers, because the buyers have good approach towards the good handholding on the lawyers, good handholdings of the judicial forums. So there are buyers who are ready to acquire these kind of properties as well. Because say suppose the property values is of 50 crore rupees. Because of the contingency involves the value comes to 5 crore or 10 crore rupees. And the buyer says that if I buy the property, after 2, 3, 5, 10, 15 hearings, I'll be able to have a handhold on the particular assets. So why not? So it is always open for the buyer. As a RP, as a IRP, as a liquidator, the only that you can do, the only task that you can do is you can give your best to the liquidation or CRP process to acquire, to get the asset sold. And the asset you are selling is for the benefit of the creditors. So of course, first to take the consent of the creditors as to what is their perspective towards the selling of these assets. And if they are agreeable to sell the assets in that mode, of course, you can proceed. That window is open for the liquidator to proceed ahead with that windows. In the
Madam,
sale certificate that you will execute,
Yes.
of course, it will be written that the sale is subject to the determination by the respective judicial forum, as agreed to by the respective buyer. The sale will be subject to this. So these disclaimers will be there in the sale certificate.
Okay. Then
And Madam, his other part of question was how to face all these investigating agencies, including that of
Yes.
CBI and all other investigating agencies.
and also the property which has been seized by the ED, etc. Then how will deal?
So it is something completely practical. Say the assets is being seized by the ED, then of course you have a right or remedy to approach the NCLT and say that if until unless the property is being given to the liquidation state or the CRP process, you'll not be able to move ahead. So respective directions has to be taken from the NCLT towards the ED so that the property can be released and can be given in the liquidation forum or the liquidation state such that the liquidator can perform his duty.
Okay.
Because ultimately the liquidator or the IRP or the RP is the officer of court. You are doing your duty pursuant to the appointment done by the court. And until unless you have the asset, you'll be completely disabled. You'll not be able to do anything. You'll be completely handicapped until unless the property is given to the picture. So till that time, of course, you have the window to go to the court who has appointed you as a IRP, RP or the liquidator to ask for the necessary remedy in that regards.
Okay, then in case investigation is going against the city, whether the IRP, RP shall cooperate that investigating agency or not?
Of course. This investigation one should also always cooperate because
If they
investigation
require
will
some
lead to-
documents, if they require some documents of the city, should the IRP, RP shall provide them?
Of course, sir, because one of the duties of IRP, RP and liquidator is also to find out the avoidance, to file application with respect to avoidance transaction as well. So this avoidance transaction, which is one of the duties of the IRP, RP or the liquidator, this includes a transaction which has happened before the commencement of CIRP or liquidation process to determine as to what has taken this corporate debtor into this particular scenario, this completely debt-ridden procedure. So the ultimately investigation of authority is also doing the same task. If the IRP and RP is comfortable enough with the procedure that is being followed by the respective investigating officer, of course, the IRP and RP can, give the necessary cooperation to the extent possible, or else the IRP RP can say that pursuant to the commencement of this CRP or liquidation process, I am also interested to do this task, and I'll appoint a forensic auditor or a respective auditor to do the forensic audit with respect to the task, and I'll provide the report of the forensic auditor whatsoever, or file the necessary application before the adjudicating authority with respect to the avoidance transactions that has happened before the commencement of the CRP or liquidation process.
If they have been seized some documents, can I ask them to provide?
So ultimately, what is the reason behind the proceeding which is going on, that you have to see? On what basis or for what purpose the proceeding is going on before the respective inspection authorities. If
Madam,
the
suppose
idea is to,
I give you an example, just to,
Yes.
I mean, with due respect to all, those who are interacting with each other. Suppose there is a matter which is under CIRP or the liquidation. Okay. My duty is to appoint, what you call transaction auditor. Forensic auditor is not in my domain unless until I have been asked or advised by the adjudicating authority. That forensic audit normally is the baby of the creditor, the bank concerned. Based on the findings of the forensic audit, there is what you call intervention of the CBI, right? Now CBI is investigating the matter. Let us go that way. So you will be summoned, right? You will be summoned to provide certain documents. Okay, you have provided certain documents to them, whatever you have. Then you receive a seizure report. Okay, suppose in this case, if this is the scenario, suppose the case goes into liquidation, the corporate debtor goes into liquidation, then I have left with no other option to sell the assets. Okay, suppose I don't have fixed assets, I have only financial assets. Naturally, I will go for regulation 37A and 38. So in that scenario, that all the documents are seized by the regulating authority or the investigating agency. Now it will be difficult on my part to sell those assets, in absence of original document.
Sir, the question has been answered by you yourself that the assets has been seized. So during the moratorium period, none of the officer can seize the asset, which forms part of the corporate debtor.
Madam, this is the problem, which has to be understood by all the investigating authorities.
And if this is such a situation that a particular IRP or RP or the liquidator is facing, that even after giving the cognizance of this moratorium, the respective inspection authority has seized the asset, then the IRP, RP or the liquidator has no other window than to go to the NCLT asking for the proper relief. You cannot, the respective inspective authority cannot go beyond something which is determined in the code and which is already determined by the adjudicating authority. So the ultimate forum is adjudicating authority to apply to the adjudicating authority and ask for the proper relief.
Yeah, it has been answered by those investigating authorities. Okay, for the meantime, I'm seizing your document. Whenever you require it, I'll just send the prospective buyer to us. I'll show you the document, or you can just produce these documents before the prospective buyer. That these are documents in the domain of the investigating authority.
Of course, sir, to the extent the documents are available within your domain, you are required to give all the documents to the prospective buyer. But when it comes to
Ma'am, I have the photocopy of those seized documents.
Sir, in your case, I will, of course, I'll say that to go approach the respective adjudicating authority will be a better option to have, the concrete.
Ma'am, we are in a very ticklish situation. One side, there's some investigating top class Indian investigating agency is asking you certain documents. You have, you cannot say no to them. But you have to.
So it is not about saying no. You have always right to provide the PDF document, but not the actual copy of the original document. And if they are wanting a copy of the document or the original document itself, then they have to produce the order of the respective regulatory authorities. They have to go to NCLT and ask for the same. How can you provide a copy of documents? Because the process, the code overrides all the other acts which are contradicting with that of the code. So of course, the IBC itself is a process that has to be separately dealt with. And if at all
Madam,
there is any particular
these kind of practical problems, like, you know, that should be dealt with somewhere in the either way on the regulation or the act, so that, like, you know, we are I mean, like, you know, informed, we can take the informed decision rather than like getting under pressure. Because see, normally we are not that all this, like, you know, investigating agency. This is the first time, like, you know, we are facing. We have never faced this kind of investigating agency during our what you call during the CA, CS and other professions.
So you have correctly mentioned. That is why I have said at the beginning of my session itself that the IBC code is still evolving and varies from case to case. And from every case, we are learning something. Every case, IBBI is getting, you know, some new concerns to be addressed to. So of course, this is also one of the concerns that I'm sure that IBBI will address to in a future course of action, and surely will be dealt by the respective regulatory authorities. So thank you to all the participants. And it was
just a small query, Let's say if after 90 days a claim is received, so RP has to go to NCLT for its to recognize the same, or can he admit it on its own after 90 days?
So, ma'am, there is a ruling which says that even after 90 days window, it is open for the IRP to accept the claim if IRP thinks that the same should be admitted. It is a case of Edelweiss. I'll just give you the entire reference. Shaivi, if it is readily available with you, can you please just give reference? It was a case of Edelweiss ARC, whereas it was says that a provision of insolvency and bankruptcy code is directory and it is not mandatory. So for the resolution professional, they should not reject the claim merely on this ground that that the claim was filed beyond this period of 90 days. And it has to be considered, it has to consider the claim based on the sanity of the time if the resolution plan is not yet been approved by the adjudicating authority.
Okay.
What was the date of this judgment? If you could,
I'll just give you the reference. So it was some 2019, I think the case was given. I'll give you the details, sir. It is included in my slides. So I'll just give it to you.
Please, ma'am, share your slide. I mean, with all the participants.
We will share this.
Ma'am, one query is there.
Yes.
Ma'am, a liquidation period has been started on December 2018. At that time, personal guarantee clause was not there. But the liquidator has done in 2021 March, he has sold the property of the personal guarantor through e-auction. So can he do this, ma'am?
He has sold the property of the personal guarantor.
Yes.
Okay.
Liquidation period has been started on December 2018, but the property has been sold through e-auction in the year 2021 March.
Okay, some of the properties you are saying were sold and
Yes.
realized. So part of the debt has been paid and it was beyond the before the changes that has been introduced. So of course, there are several cases in this regard, ma'am. If you have seen, you know, it is very common for the promoters to give guarantees with respect to the dues of the corporate debtor. In all the cases, almost all the cases, the promoters have given guarantee with respect to the dues. So, and the, you know, basically by way of pledging the shares and the respective it has been seen that the financial creditors have invoked the pledge you know, ultimately, or it has been seen that the corporate debtor or the IRP or RP has sold the assets of the corporate or the personal guarantor with respect to the realization as well. So these cases are there, and of course it was before the initiation of the process, so it is in line with the then applicable regulations.
Ma'am, can you give one case law for the same?
Sorry, ma'am.
Any references of the case laws for the same?
I'll refer for the same, ma'am. If I'll file, I'll surely include that in the part of this PPT and will share with the same with you.
Okay, fine.
Just one question, ma'am. Can I ask?
Yes, of course.
Yes. To determine the proof transactions, a 2 years period is there. If the fraud has done before 5 years, so what the IRP or RP shall do?
This 2-year period is from what? From the date of commencement of the liquidation process or CRP process.
Yes.
Now the question comes as to when I am not there in the picture, How can I go beyond the 2 years? How can I just say that this is pursuant to this only? So one has to see that whether the transaction which I'm alleging is of continuous nature or not. So if say suppose some fraud has happened in 2010 and which is
Yes.
still continuing. So it is of continuous nature and it still exists. For example, say suppose the trademark of a company was assigned to a related party of a corporate debtor for no consideration. There are related party of a corporate debtor. The corporate debtor has given the trademark to the related party at no consideration. Or say suppose there are properties of the corporate debtor that corporate debtor has given to the related party for no consideration.
Okay.
Of course, this particular transaction is hampering the financial creditor's debt.
Yes.
In that case, one has to see whether this is of continuous nature, whether at the time of commencement of CRP or 2 years beyond before the CRP, whether this transaction was of continuous nature. If the transaction is continuous nature, such that the property is still being held by the related party and the related party is not paying any cost, then that continuous nature of the transaction has to be adjudicated upon, and accordingly, the avoidance transaction application is open for the IRP or RP to file.
Suppose, madam, suppose the transfer has taken place to a third party within this 2 years period, then the third party could be court holder.
Yes,
Under,
yes, of course,
yes.
within this 2 year period, of course.
Even if it has changed hand during this period.
Yes, yes, of course. On what basis the transaction has happened, and if it is found that the transaction was completely fraudulent, then adjudicating authority has all the right to reverse
66.
the transaction. To reverse the transaction that has happened.
Thank you.
Thank you. Thank you so much.
Thank you. Thank you, everybody. Thank you to ICSI IIP team. We'll be looking forward for more such sessions.
Thank you very much, ma'am, on behalf of ICSI IIP and all the participants for such a wonderful and insightful session.
Thank you.
Thank you.
Thank you.
Please share the PPT.
Thank you, ma'am. It was really wonderful presentation.
Yes, sir. We will share the PPT with the ICSI IIP team, and they will share with all the participants.
Thank you, ma'am. Thank you very much.
Thank you.
Thank you.